I have been engaged yesterday, my lord. Today, let me go through you.
6,
Let
7,
him,
8, 9.
after 2 or 3 weeks.
6, 7, 8, 9.
And along with my lord, there is another item, analogous, double petition 2398. 2398 of 2024.
Just wait. These are similar matter.
Similar. And one more.
Analogous matter.
Yes.
What is the matter?
My lord.
What is the matter?
I've already gone through that. I've even handed over to me. I was engaged yesterday.
You didn't have the time to go through yesterday.
Hello?
You didn't have a time to go through yesterday.
I didn't.
Yesterday, you didn't have a time to
No,
go through.
yesterday, file was handed over just now.
So this will be listed together.
Together.
I'm asking whether it's
Yes.
a analogous matter.
Analogous. All.
Okay. On the Mr. R.P. Sharma, the senior counsel, submits that in this 6, 7, 8, 9, 10, in this submits that he has been engaged yesterday in these matters, in these matters. Therefore, praise that matter will be listed after 4 weeks. 4 weeks.
Along with my lord, WPC number 2398.
Along with WPC 2398 of 2024.
24. All right.
May please, your lordship.
Yes.
My lord, I beg to mention for item number 27.
Yes.
My lord, here in this case, my lord, the respondent number 8 has filed an affidavit in opposition. My lord, we
27, 28.
my lord,
27.
27, item 27.
Yes.
My lord, we need to file a reply affidavit.
Running counsel for the petitioner list this matter after 2 weeks so as to enable him to file affidavit in reply to the affidavit in opposition filed by the respondent number 8.
Deeply obliged.
May I please, your lordship?
Yes.
I would like to withdraw item number 2. It has become infractuous, your lordship.
Yes. Hope so. Mr.
A.R. Shom.
A.R. Shom, learned counsel for the petitioner, submits that this petition has become infractious. In view of law, writ petition is dismissed as infractious.
Yeah, please, your lordship.
Oblige, your lordship.
May I mention item number 37 to 52, my lord. My lord, in this matter, I am appearing for ASTC. My lord, may I pray the matter may come up in the second week of May. In the meantime, I'll file my affidavit as well as Vakalatnama.
I am for the petitioner.
37 to 58. What is this?
Retirement benefit matters. Retirement benefit matters.
Retirement benefit.
Any objection?
If it is required, my lord, I have no business. Only a date may be fixed.
Corporation. It's a corporation.
Corporation.
The date may be fixed, my lord.
Second week of May, any date, my lord. 14th of May.
On the prayer of Mr.
M. Sahewala, my lord.
M. Sahewala, that is standing counsel.
My lord. ASTC.
ASTC. This matter after 3 weeks. No, on the prayer of Mr. So-and-so, learned counsel to so-and-so, and prayer not being objected to by Mr.
MAI Hussain.
MAI Hussain, learned counsel to the petitioner. List these matters after 3 weeks. In the meantime, the ASTC, learned counsel for the ASTC may file its affidavit. Affidavit in opposition. File the affidavit in opposition.
The date may be fixed, my lord.
3 weeks, we'll see. List after 3 weeks.
My lord's kind permission. May I mention item 56 to 74, my lords? I'm not seeking an adjournment. I just wanted to inform, my lords, that my lords were pleased to grant a stay last time in our favor. The state appealed before the division bench by an order of 2nd April, where they gave a concession in our favor. The division bench has requested my lords to take up these writ petitions today and consider disposal on the basis of their concession. So I'm just bringing it to my lord's notice, just in case it doesn't reach.
It may not be possible. Why this has been listed for orders?
Well, it has been listed for orders on the basis of the.
Why this is part third? It's not a part third.
And it is a part third, my lords. On the last occasion, my lords.
Have you been considered?
Have you been?
Are you been considered?
Yes. They have given a concession that will be considered.
Then
on that basis,
we'll take it after Bihu.
I'm sorry, my lords.
We'll take it after Bihu.
The only
because you are being considered.
The only difficulty is
we thought if the matter if your case is rejected before hearing, we thought that's the reason we have fixed.
Yes.
So it's not possible today.
The issue is,
Rather, it is fixed for, fixed on, fixed, listed for
it is
order.
listed today, my lords. It is listed today.
Huh?
It is listed today, my lords, 56 to
We'll
70.
say, we'll see.
When it comes, my lords, may
No, no, this is something, we have fixed it today,
Indeed, my lords.
uh,
And it-
considering the interim order was granted.
Indeed, my lords.
And we thought that once they started verification without
Indeed, my lords.
your case, without
Indeed.
considering your documents,
Indeed,
we
my lords.
thought it
So
may
therefore,
cause
today,
prejudice to you.
indeed, my lords.
Now this process is up to 11.
Indeed, my lords.
So whatever is there, we'll see after the vacation.
Yes, there is a reason to that, my lords. When the matter is called, I'll just need 2 minutes, my lords, and the writ petitions can be disposed of on the basis of the concession that they've given, that we are eligible and will be considered. Nothing would survive in
No,
the writ
if
petition.
that is the case, but if it needs
It won't be an adversarial litigation, I assure my lord. So it will
Okay.
just take 5 minutes, not more than that.
you talk to the advocate.
They,
general.
the order records that. The order records that they are saying it in our
Talk
favor.
to the advocate.
Very
general.
well.
Advocate
Let
general
the
will
matter
do.
be called out as it comes. I just wanted to bring it to my lord's notice.
Otherwise, if it is takes, for.
No arguments, my lords. I assure.
normal
If it is for,
hearing, I'll
I
not-
understand, my lords. I understand the difficulty. It won't be arguments, my lords. Just 2 minutes.
And
from
I
this-
came to know that was passed on the, on the open court, so.
Indeed,
There's a mistake in the order also. In last,
my lords.
I've noticed, I don't know why, who has typed this? Item 50, what is that? Order
56 to 70.
56. It should be, shall not be, may not be taken up. B word is not there in
Indeed.
the order. It looks very odd.
I understand. Well,
It's not-
but because of the development of the division bench's order,
No, what I'm saying,
I
the
understand.
order passed by the interim order
my lords,
should have been, the language should have been, it may not be taken up. It said, may, it's,
B is not.
may not, B is not there.
My lords, we have been taught since day one that boss is always right. So
It's-
therefore, my lords,
It's
we
very,
didn't
it's
consider
a
it.
silly mistake.
My lords,
I could notice it. This is the problem.
so 5 minutes when the matter is taken up, and on the basis of that order, my lords,
If it is 5 minutes, it's okay.
my lords,
Two
not
line-
more than
two
5
line
minutes.
orders, two
Looking
line
at the watch.
orders.
Looking at the watch.
Yes.
Grateful.
May I please your lordship? I'd like to
No,
question-
that's why I'm saying you talk to Advocate General. I've seen the order of the division bench.
My lords,
Since your case has been considered, then why unnecessary?
I will discuss and I will
litigation?
report by 1 o'clock.
Yes.
Before lunch, I will report.
Yes.
Grateful, man.
Your lordship, I would like to mention item number 29.
Hmm.
We have for the respond number 6. Lordship, we've taken the due consent from them.
Hmm. Item 29.
Yes, your lordship.
Yes. What do you want?
Your lordship, this matter may be adjourned for the day
Therefore,
for UGC. Respond number 6.
on the prayer of Mr. So-and-so, learned standing council, list this matter after 3 weeks.
May I please your lordship?
3 weeks.
Yes, your lordship.
May I please your lordship?
Ah,
I beg to mention item number 5.
why?
Item number 5.
Why? It's a motion.
Yeah, your lordship, my senior is not well today. So kindly,
Who is your senior?
SK Sigdar. SH Sigdar.
He was here. Okay, that's it. Okay. MS,
SH Sigdar.
your name?
My name is Nikoli Jijimomi.
Ah. Learned counsel
Yeah, so
appearing on behalf of Mr. S.H. Sigdar. Submits that her senior, Mr. Sigdar, is indisposed today. Mr. Therefore, praise for adjournment of the matter. Mr. Prayer the Lord. List after 4 weeks.
the 4 weeks. Thank you, sir.
Yes,
Wait, Mr. Lord. A matter pertains to a non-payment of salary
yes.
for a particular period from 27/7/2011 to 19/10/2012.
Yes. Will issue notice?
Yes.
That's all. Heard Mr. P.J. learned counsel for the petitioners. How many? 3 petitioners.
No, my lord.
12.
Yes,
You are working as,
assistant teacher.
okay. By filing this writ petition, the petitioners had prayed for a direction to the respondent, which is to provide the regular scale of pay No, to provide, to pay regular scale of area, regular scale of pay
Yes,
from the, with effect from 27/07/2011 to 20/12/2012. This is period of what period?
my lord.
Before your regularization. Before your regularization.
After regular,
You are regular on,
on 27/7/2011.
okay, then
Then that period,
why 12 you have not been paid? Till 12, why you have not been paid?
well, after 2010/2012, regular pay has been paid, my lord. But before that, this period was not paid.
Why you have not been?
Well, why they have not paid, my lord, that is the question. That's
Claiming that even after regularization, the regular scale of pay has not been given to the, paid to the petitioners till 2012. Issue notice returnable by 4 weeks. Since Mr. All of,
And for one.
all are you, all you, are you,
3, 4, 6, 7, and 8, etc.
who is for? Since Mr. P.N. Sharma, London Standing Council,
So the response number one.
Elementary Education, and Mr. D. Chaudhary, Learned Council, Land Standing Council for
3, 4, 6,
BTC.
7, and
accepts notice, enters appearance and accepts notice on behalf of respondent 1, 3, 4, 5,
3, 4, 6, 7, and 8.
3, 4, 6, 7, and 8. No formal notice. Need this out. We still have the accepted promise to the land council. The petitioners to take stage for judicial notice upon respond number 2, 4. You are 3, 5, 6, 7, and 8. And then in that case,
5 is finance.
okay. So then in that case, 1, 2, 4, 6, 7, and 8.
Lordship 3, 4, 6, 7, and 8.
3,
I am for one.
6, 7, 8. That's why I said no. Accept notice,
Two and
enter
five is
appearance and accept notice on behalf of respondent number 1, 3, 4, 6, 7, and 8. Then in the same, then petitions to take stage for service of notice upon respondent number 2 and 5. You just serve the copy, the standing council
my lord.
by furnishing the copy to the Land Standing Council for that.
2 and 5.
Number 2 and 5. Within 2 days. List after
After, my lord.
return after 4 weeks. List after 4 weeks.
Oblige.
In this case, my petitioner was working as a stipendiary teacher, my lord. His name is Fariduddin Borboya. Response number 6 is the Fariduddin Lashkar, my lord. When the government ashram accommodated the stipendiary teachers as tutors, my lord, then
Yes, instruction.
Lots of here, my learned friend has annexed one similar order. So lots of may dispose of with the petition, this petition. Similar,
What is the similar order?
page number lots of 30,
13.
30.
Okay.
Here also, and the operative portion, lots will find. Page number. Uh, 31. Page number 31, the last paragraph. It is a case wherein two persons having same names rely on an order of accommodation for instance. So the lordship may dispose of with the similar
Similar name. Here also similar name.
lordship. The two
name
names.
is similar, the, my lord, the surname is different, man. One is Borboya, one is Lashkar.
They will verify.
In
Department will
other
verify.
cases, the spelling was
No, you obtain instruction.
Lordship,
Why
otherwise I
that
will
could
obtain.
My lord, the instruction, my lord, for a moment, my lord, page number 24, my lord, for a moment.
Ah,
Page number 24, it is clearly, my lord, mentioned from the director, my lord.
Firozuddin Laskar.
Yes, I am the, my lord,
You are Firozuddin Laskar.
Borbuja, my lord. In the third column, my lord, kindly third column, my lord.
Hmm.
In your proposal, it is seen that the name of the tutor is Fariduddin Laskar, but as per government list, the name of the tutor is Fariduddin Borbuja. I am Fariduddin Borbuja, my lord.
Hence clarify and submit.
Clarify and submit below.
Ah, so,
So, my lord, they should, in as per this letter, my lord, they should, my lord, take my lord, instruction.
I will obtain
This-
instruction.
this letter.
last time we have asked for instruction only.
And otherwise, my lord, notice may also be issued because the
Notice-
private respondent is there, my lord. Respondent number 6 is there. If anything is,
Heard Mr. So and so, learned counsel for the MG Khadir,
yes,
learned counsel for the petitioner. Next minute. The claims. The claim of the petitioner is that he was selected and appointed as a tutor in the Indira Gandhi LP school in the district of Hailakandi. However, the respondent number 6 has been illegally allowed to serve in his place as a
tutor.
tutor. Despite the fact that the respondent number 6 was not selected. This issue notice returnable by 4 weeks. Next period, since Mr. Ian Sarmalan, standing council, elementary education
Lordship,
appears, enter appears for enter appearance and access notice for all the respondent for the notice signatures, otherwise exporting permission that land council to the respondent. Mr. Considering the having considered the nature of the grievance raised in this situation, this court directed the learned standing council to obtain instruction by an order dated 01/02/2020. Accordingly, the the learned standing council to obtain instruction is directed by this court on 01/02/2020.
Okay.
This after
notice, no?
Yes.
May I please, your lordship, plus the matter regarding the transfer of the petitioner are from Lahorighat Education Block Morigaon to Govardhan Block
nothing.
Baksa, lordship. So last occasion, the department has taken time to bring instruction.
Yes. What is your right to continue in a particular place?
Lordship, as per transfer order, it has been reflected as per latest guideline of Election Commissioner of India.
It's
During
over.
the Lok Sabha election,
It's
lordship.
over now.
It's over, lordship. Lordship, during period of 15 days, the petitioner has been transferred in twice, lordship. It is the main ground.
Not 15 days is too long a day. Can we transfer within 1 day also?
No, lordship, as per ECI guidelines, it has been transferred within the period of 3
Yes,
years.
we
lordship.
for the respondents.
Transfer order was modified, not significant.
Modified.
Yes, madam.
Then
Regarding this, I have no instruction, lordship. Let provide me copy and matter me fix after vacation, lordship.
no. You are disposing.
Lordship, let him provide the copy, otherwise I have no instruction regarding that, lordship.
If the transfer order is modified, nothing remains. You may challenge that whatever is there.
No, lordship, actually, I don't know regarding this order.
Let me see. We'll provide you the copy. Xerox. He has been transferred to some other place.
Yes, lordship.
So
There's
it's
been
a fresh-
transfer posted on B.Ed Patharkandi Education of Karimganj.
Yes. Press cause of action. That your challenge is no longer here.
Yes, no,
No longer
otherwise,
in
first, madam.
We are closing it. Or are you withdrawing it?
Was it tomorrow, Lordship?
No, no.
I'll fix.
It's an order of 2024, my lord.
It may be, but
Tomorrow
Lordship,
will
I
be
have
another
more regarding,
huge list will be there tomorrow. Therefore, whatever is there,
thereafter tomorrow,
No.
Lordship.
this week it's that.
Was it tomorrow, Lordship? I
No,
may
no,
have,
no. Let me see, what's there? We'll give you the copy.
No, copy has not been provided yet,
Will
Lordship.
be
Therefore, I am
provided.
asking for time regarding,
Yes, no.
Lordship. So maybe fix on tomorrow,
No,
Lordship.
no, sorry, sir. With reference to
Okay.
something, I would like to inform you that government issued a notification so and so 5/4/2020, whereby the earlier government notification.
এখানে হিসাব নাই, এটা বেশি কাম হয়েছে তো। কাম হয়েছে কি খবর বলে, কাম না হলে
Country Education Block of Karimganj District Convention. This is order is of 2024, April 2024. If your petition, if the petition doesn't inform you. what can
Petition
we-
filed on February 24, Lordship.
So, thereafter,
I
Today
have
is
not
what?
received instruction,
no,
Lordship.
I thought this order might have been issued recently, 1 year back.
1 year back, my lord.
Kindly matter will be taken
No, no.
after some time,
No, no.
Lordship.
Huh?
After some time, Lordship.
Why?
I contacted my,
Sir, this order it cannot be false.
me.
Partial modification, so and so. What is your challenge?
I have challenged the order dated transferred from Lahorighat, Morigaon to.
No,
Govardhan Block,
now you
Baksa,
have been
Lordship.
transferred to Patarkhandi, Karimganj.
Lordship, regarding this notification, just I come to know that, Lordship.
Sir, this was order issued to you, to your client, 1 year back.
Maybe, Lordship.
If you have not been informed by your client, what can we do? You are a teacher.
No, block elementary education.
After some time, think about it. Otherwise, this thing
Lordship.
is. After 10 minutes, sir.
May I plead, Lordship?
Yes,
Lordship, this matter pertains to compassionate appointment, Lordship.
so,
Lordship, on the last occasion, respondent is asked to bring instruction, Lordship.
yes. Pegu sir. Where is Pegu? Ji Pegu.
Chipeku, he is in court.
You are appearing.
Yes, your Lordship.
So, what is the instruction?
We have sent the communications, but no instruction has been received
Why?
twice.
See, madam, you have applied in 2011, then you have approached in 2012, and you have filed this writ petition in 2024. After 12 years,
I have a submission, Lordship.
what submission?
Lordship, in para number 10, Lordship.
What is here?
Lordship, the petitioner has been approaching the office of the inspector. Lordship, the documents have been misplaced, Lordship, from the office, Lordship.
For 12 years, you didn't do anything.
Lordship, 2012 have been approaching in the consular authority, Lordship, for a
Then-
several occasions, Lordship.
Then
There,
the office of the respondent also never disclosed the said fact till the end of 2023. Then 10 years you didn't do anything.
they have assured me, they have assured that my case has been placed, that my case will be placed, Lordship.
For 10 years.
Lordship, I have approached with the concern of.
10 years.
Assured me.
You approach, keep approaching now also. Anyway, I may heard MS so and so learning council issue notice returnable by 4 weeks.
Okay, sir.
Mr. D. Pegu. No, B. Devi, learned state council appears for. Or appears and accepts notice on behalf of all the
I'm
respondents.
for respondent number 4,
One and two, I'm again.
1 and
1,
2.
2 and 3.
1, 2 and 3.
Yeah.
Mr. Swenser. This Mr. N.J. Khatenia, the understanding of the, and Mr. B. Devi, Learned State Council, enters appearance and accepts notice on behalf of all the rest, no problem. notice.
I'm for respondent number 4.
However, petitioner to furnish extra copies during, within 2 days.
Okay, sir.
Objection, any objection? No. No objection. Heard, Mr.
N. Borua.
And Land Council for the petitioner. This is an application. And also heard MS
8 Talukdar.
A. Dasgupta,
8 Talukdar.
A. Talukdar, London State Council for the opposite party. And consider the applicant, huh? Next paragraph. This is an application going for impleadment of who? Implement of the life insurance, yeah, what is
LIC, Life
LIC.
Insurance.
Life Insurance Corporation of India
Respondent number.
as respondent number 6 in connected WPC 6971 of 2021. Next paragraph. Having considered the submissions of London Council for the parties and also on perusal of the grounds set forth in this application and prayer not being objected to by the London Council for the opposite party, comma. I'm of the view that the application, I'm of the view that the Life Insurance Corporation of India is a necessary party for proper adjudication of this present writ proceedings. Proper adjudication of the writ proceedings being WPC 6971 of 2021. Thus, I deem it appropriate to allow the application accordingly. The application is, the present application is allowed. And the life insurance company, what is that? The Life Insurance Corporation of India, represented by regional branch, be allowed to be included as respondent number 6 in the connected WPC 6971 of 2021. With higher instance allowed in disposal. In writ petition, in view of the other parts insurance, in IAS insurance, the London Council for the petitioners to file amended post-dated, which thereafter raised to do the need. This London Council for the petitioners to, no, in that case, then they have issue notice to the newly included respondent number 6. London Council for the petitioners to take its steps for service of notice after this. After implement of. After implement. No, after necessary incorporation. List after 4 weeks.
Yeah, pleases your lordship.
Yes.
Learned counsel, Mr. Ayer, who is on late at another courtroom.
Hmm.
Lordship, matter may be take after some time.
After some time.
Well, can it be fixed at 2 lordship? That I have some other matters.
No, two. You be there.
Look.
Otherwise, we'll adjourn. They'll be seeking adjournment.
That I want to dispose of this matter to the HL.
Let us see.
Only because of some interim order, lordship, sir, we cannot conduct it, that
We'll see.
selection process.
We'll see.
Lordship.
You have completed the selection process.
Some of the districts, my lord, it is still, my lord, that,
We're not concerned about the other district. These are all so many districts.
this is, Lord Chief, my lord, there are several repeat petitions, my lord. There are only the South Salmora district, my lord, selection process has been completed.
Then others,
And others, my lord, due to some interim order, my lord, we could not be conducted to the selection process.
you will see.
Lord,
Actually, can you pass it over this matter for?
What is the matter?
This matter is for nursing uniform.
What is? Yes, Mr. Gyan, A. Gyan. Miss A. Gyan, Miss A. Gyan.
I am on behalf of R. Mazumdar.
I know, but in view of the order passed on 0104, 1st of April, gets hold of MS Agyan. She was directed to obtain some instruction. After some time, huh? Yes, I think
May I
so.
please, Your Lord?
Yes,
Procedural rightly pointed out that matter has
Matter has
become
become
influence.
yes. Mr.
P. Guhailers.
P. Gohai, learned counsel for the petitioner, fairly submits that the writ petition has become infectious in view of the order dated, huh?
11/3/2024, Lord Chief.
Order
Interim order
dated,
the earlier part.
no, 05. Huh? The order is second page,
28/2/2024, impugn order, Lord Chief.
05/04/2024. In view of the issuance of, in view of the issuance of fresh transfer order dated 05/04/2024. Accordingly. What I say? Fairly submits that the writ petition has become, yes. Accordingly, writ petition is dismissed as infructuous. Yes, B. Gogoi. Instruction. None appears for the petitioner on call. Next paragraph. Who is appearing for the respondent? It is next paragraph. It is noticed that on the last two consecutive occasions, i.e. 11/12/2024 and 21/01/2025. Also, petitioner was known. Non appears of the petition on call, list to matter after 4 weeks.
Well, that will be taken up after some time.
Why? What is the matter?
Relating to the continuation of age, my lord, because my
Huh?
lord, premature retirement, my lord, correction of date of birth, my lord.
Have you filed the amended cost title?
Yes, my lord. Taken up after some time, my lord. I have no brief, my lord.
No, what is
Well,
to
I
be
am-
done today? Pleadings are complete.
Complete in fact, my lord.
After vacation.
Admission hearing, my lord, since they are not receiving any salary
Council for the petition.
since 2017, my lord.
As paid for by the land council for the party. Miss this matter after 2 weeks
After the,
for admission.
my lord, the date
Two
will be fixed, my lord, since the petitioner has not been received any salary, my lord, since 2017, my lord.
We'll see.
And
2
one
weeks.
petitioner is already
We're
expired.
fixing it 2 weeks. Listing it after 2 weeks. Thank you.
Lordship, I am appearing on behalf of Mr. Esnath, who is on lapse. Kindly pass over for the time being.
You cannot pass over all the cases. Yes. What is the matter?
Petitioners are as casual official staff. They are, after their engagement as casual staff, the petitioners are working as computer assistant cum clerk, except the petitioner number 5. The petitioners are working sincerely at fixed wages rupees 8,000 per month, but all of a sudden, from the month of January 2019 onwards, their month's wages have been stopped without assigning any reason. They have submitted their representation on 18/12/2021, 7/3/2022, and 1/6/2022. A release of their wages, but and for regularization of their services, but yet not resolved.
Yes. You are seeking release of your monthly wages or for regularization?
Lordship,
Regularization were not.
Lordship,
Monthly wages, yes.
Lordship, some time may be given to offer instruction.
Why? Last time also
Lordship.
PNRD
Lordship.
placed the inspired as to why the prisoner claim for monthly wages for month of January had not been fully credited. Yes. On 26/3. You were granted time to obtain instruction.
Last chance may be given.
Heard MSO and Land Council for the petitioner. Despite granting time to the Land Standing Council, PNRD, on 26/03/2025, no instruction has been put for, has been placed. The Land Council, MSO and to obtain the instruction is directed by this court on 26/03/2025. On the next date. List of after 3 weeks.
Obliged.
Please, on the last occasion, madam, the government was seeking
Yes.
time, madam.
Government,
Compassionate.
Appointment in Suchi.
compassionate appointment.
My lord.
Yes, Lordship.
What is
I
your
have, I
case?
have challenged the appointment order of the respondent number 9, my lord.
Okay,
Yes,
so,
56.
Yes.
So no affidavit has been filed by the event respondent, private respondent number 9. my lord.
respondent
There is
number
a
5,
private respondent is also there, Lordship.
who is appear, service is complete.
Service complete, my lord. I
No,
taken
it's okay,
step.
who appears for respondent 5? Who is respondent number 5?
YS Mannan, my lord. Name shown in the cause list, my lord.
Huh?
Name shown in the cause list, my lord.
Who is the main respondent?
YS Mannan, Lordship.
No, forget about the private respondent. Who is the estate?
I am appearing, Lordship. I am appearing for the Deputy Commissioner and Education.
Yes, who has to reply, respond?
My lord, government, my lord.
Government,
Yes, Lordship.
have you filed the affidavit?
No, Lordship. No, sometime may be allowed, Lordship, in this case to file affidavit.
Land Council for the petitioner. Next, on the prayer, MS,
DD 11, additional senior government advocate.
additional senior government,
Yes, Lordship.
and MS,
D Musari.
you have filed the affidavit? No.
Lordship, we have not filed.
And MSB Musari, that is standing council for
For secondary education.
secondary education department. Granted further 3 weeks time to file affidavit.
My lord. Apply.
So I'm sorry to interfere. So for the item number 29, I came to know that this matter has been adjourned, but I have not been informed. They are supposed to, for the UGC on many occasions, they took time to file affidavit. Today also, without informing me, they have already adjourned the matter. This matter has been adjourned for 3 weeks. They are supposed to file affidavit, but without informing me,
Let's see, next time we'll see.
then Lordship will fix the matter, because today is supposed to.
3 weeks, 3 weeks.
It's a date we figure. They should inform.
No.
The UGC has not informed me, Lordship.
You're supposed to inform.
The
Call
21.
him, call him. Call him who is not informed. Why he has not informed?
Your Lordship will fix any date or no.
No, after 3 weeks, order is.
Lordship, then that way fix, Lordship.
Why? What is the
There
matter?
is urgency, Lordship.
What are this?
Sir, regarding the appoint selection and appointment, Lordship, is
Give the date after 3 weeks. No, you right? Item
item 29, Lordship.
29.
Okay, I'm sorry to
Next,
interfere,
next,
Lordship.
next date, the next down the line, you right? We have granted so and so. After passing of the order, Mr. So and so,
A Reka, Lordship.
and concept of the petitioner. May they mention that the learned counsel for the UGC has not
Yes.
informed him about the.
Some message should go, Lordship.
Therefore. Objected the granting of Mr. Herbert considering the response of the UGC is required for paper eligibility, the prayer granted hearing above this. Is it continue? Mr. Herbert, and then fixing the date as sought by the petition, the counsel for the petition on 6th May.
Apply.
May I please say, Lama? PAC has not filed affidavit, madam.
Yes. What is the matter? No affidavit, who is for the state?
PNRD, pending council, PNRD.
PHE. Jal Mitra,
Yes,
you are a friend of
yes,
water,
madam.
friend of water.
Yes, madam.
No one can be. Except you, no one can be a friend of water. Huh? What is your right?
Madam,
Why you
Only-
should only be appointed?
madam, it is appointed my senior, madam.
Huh?
Arguing the another, madam.
On the prayer of Mr. Your name, please.
A Khalek,
A Khale. Khale.
A
Khale.
Khalek.
London Council for the petitioner. List this matter after 4 weeks.
Obliged, madam.
Petitioner is the RPF constable.
Huh?
RPF constable. He was the RPF constable.
Yes.
Affidavit file.
Okay. So,
He was initially removed, my lord, without.
okay, against the removal,
Removal from
Learned
service.
Mr. So and so, London Council for the petitioner and
B Sharma,
Bishop
CGC.
Learned CGC. Admit the petition list for hearing after 3 weeks.
After
3 weeks.
All right.
Hearing, huh? Please also, petitioner put under suspension, my lord. So, my
Yes.
lord, the petitioner filed to reinstate him, my lord,
Hmm.
pending departmental proceeding, my lord.
Yes.
Last date, my lord, when the matter was listed on, my lord, 21/6/2024, my lord.
Yes.
The learned friend from the forest, my lord, standing council make an objection that I have not appearing in the office regularly, but I have appeared, my lord. Then accordingly, my lord, next day I have to ask to appear, I have appeared, my lord. Until I am continuing my office, my lord, though I am put under suspension, I am regularly attending office, my lord. Because as per order, I have not to leave the jurisdiction of the
This order has been complied with.
complaint, my lord.
Then
Yes.
Yes.
Only thing is that, my lord.
Nothing remains.
As per the Ajay Chaudhary, my lord.
Virtually your relief has been granted.
No, my lord, I am still under suspension, my lord.
But then you are allowed to continue.
No, my lord, only allowed to, direct to appear office in the regular ledgers, I am appearing. I am
Huh?
getting the suspension allowance, still I am under suspension.
What is the order? Let us see. If what is incurred, direct the petition shall appear before the central checking range. Office of receiver claim and have his presence recorded by the state authority that is the donation. Presence should be provide him with a written certificate and submission and copy there will be provided to the both sides before the court on the extent. Yes, any certificate.
My lord, they have not given me the certificate, my lord. That's why I expect that my learned.
No,
friend produce
documents shall be produced by both sides
My lord,
before the court.
my lord, the forest department approves standing counsel from the forest.
No,
but they
sir, you have also.
I have not given, my lord.
You
because
have not also been directed to produce,
My
both
lord.
sides.
I have, they
The
have
said
not provided
documents
to
shall
me,
be
my lord.
produced by both sides before the court on the next date of this week.
They have not provided to me, my lord.
Who is for forest? Forest. D. Gogoi. Who is D. Gogoi?
The impugn order is, my lord, page 19 in extra 1, my lord. Suspension order, my lord.
No, that's the reason. This is another second petition you have filed.
My lord,
Then,
that issue has been raised, my lord, from the last time, my lord,
Ah.
regarding maintainability, my lord.
yes.
So until unless the one decided on merit, my lord, the cause option remain, my lord.
There is a judgment of the Supreme Court.
My lord.
Dismiss.
No, my lord, I have to, my lord, I have to refer to one judgment then, my lord.
Which does Mr. D. Gogoi? Forest? Yes, madam. Forest Department, Standing Council. There's a specific direction. You are also supposed to produce. You see, court has directed you to.
My lord, then, let,
So once you are allowed to attend the office,
no, my
right.
lord,
okay,
my
just wait. There's the reason this order was passed.
my lord.
It's not passed on the air, sir. You said you attend the office, but then your your attendance is not being accepted. But they said you are not attending the office. You filed a writ petition that was dismissed, being not pressed. You have not pressed it. There's another writ petition which is pending. How can this third, fourth writ petition can be filed for same cause of action?
My lord, maybe come after vacation, I'll produce my lord, that my appearance, my lord. Because they have not provided, I pay for
That's
that, my
the
lord.
reason. If you have produced, we'll close the writ petition. With the question of suspension, if your attendance is accepted,
My lord,
what they are saying that you are not attending the office.
my lord. There are some,
Therefore,
I am
court has
absconding, my lord.
directed you to appear, attend.
My learned friend
So
will
the
ask,
question of suspension now.
Lordship, we have sent message, Lordship. Can it be taken after a while,
After some
Lordship?
time. Or else you withdraw it.
Lordship.
Is not it, Mr. Sarayana?
my lord, this petition is
No,
maintainable,
not
otherwise, my lord,
maintained,
that
not
my
maintained,
appearance
not
is, this is
maintainable.
different thing, my lord.
Number one, multiple writ petitions. One after another.
My lord,
After
while
withdrawing
withdrawing the
after
petition, my lord,
without liberty.
my lord.
Same
That,
cause of
well,
action.
that was missing, my lord. That is the
Same
difficulty, my lord.
Same cause of action.
But with the
Number one.
purpose to
Number two,
file a fresh,
you are saying that you are attending the office. This court has directed you to attend with a certificate shall be issued and you will produce it along with the other parties, respondents too. Matter ends there. You are against the suspension.
my lord.
Think over it. But dismissing or withdraw it.
That my brother friend appear, my
That will not depend on them, in fact. Will depend on you, your case.
lord, then I have to place the one judgment of the Supreme Court, whether it is maintainable or not.
Yes.
এটা কপিটা আছে না? আছে, আছে।
Yes.
My lord, so my lord, did earlier, there one mistake is there from my side, my lord. While doing the petition, my lord, that has been, my lord. That otherwise, my lord, this is not based on merit, my
This
lord,
is basically on res judicata.
my lord,
Last line you read.
my lord. So res
It is in
judicata
the
is,
light of this, there will now proceed, I'm sure. To make it crystal clear, confusion thus reached by us are confined only to the point of res judicata, which has been argued as a preliminary issue.
so this one, my lord, did petition lie, my lord, it is not
dispose on merit, my lord. So it is even withdrawn by me, my lord. To file, only thing is that word, my lord, with a liberty, that
We'll
word is
take it-
missing, my
take
lord.
it up.
I
We'll
did
hear
not pray,
that
my
in
lord.
First one. MB.
Petitions. Lordship, I'm appearing on behalf of Mr. M. Soikia.
Hmm.
Lordship, he went to the Kohima bench for a hearing. Therefore, pass the matter for today. And Lordship, the matter is important. So if possible, can you fix a short date?
On the prayer of Mr. So-and-so, learned counsel appearing on behalf of Mr. M. Soikia, learned counsel for the petitioner. On the ground that Mr. M. Soikia, learned counsel, has gone to Kohima bench for other urgent hearing matter. Therefore, praise the, therefore. No, what is it? Not on the Mr. So-and-so, learned counsel appearing on me, Mr. M. Soikia. Submits that Mr. M. Soikia, learned counsel by the petitioner, has gone to Kohima bench for some more other important matters. Therefore, seeks an adjournment of the matter. The, having considered the prayer of the learned counsel to be little strange, however, when the prayer of when we ground that the Mr. M. Soikia, learned counsel is not present today, let this matter be listed after 6 weeks. Along with that. Supplementary item. That's it.
May I please, Your Lordship? My lord, the petitioner hearing, my lord, has been appointed, my lord, as grade 4 employee, my lord, as a
Yes.
Zugali, my lord, but she has not been, my lord, allowed to join. On the ground, my lord, in the online form, my lord, I get tick mark under the column ex-serviceman category. But actually, I do not believe that is my bona fide mistake, my lord. I got filled up my form, my lord, through internet. gate,
Meetings
my lord.
completed.
Pleading completed.
And Mr. So-and-so, learned counsel for the petition. Your name, please?
AFNU Mullah.
Huh?
AFNU Mullah.
Learned counsel for the petition. And Mr.
H. Chakraborty, Lordship.
H. Ugrapur.
Respondent number 1, 2, and 5, Lordship.
I missed the petition list for hearing after 4 weeks.
My lord, kindly date may kindly be given. Appointed already, but that I am not allowed to join, my lord. My lord, kindly one date, my lord. It's delaying, my lord. Simple issue, my lord.
It may be very simple for you. For us, it's not that simple.
But this high court, my lord, held that issue also. my lord.
Okay.
So
We'll
that,
see, we'll see. That's why your matter has been admitted. That's the reason we have admitted your writ petition.
obliged, my lord, for that, my lord. But only I prayed for a date, my
Yes,
lord.
yes, thank you.
Well, in this
Obliged.
case, the government has filed affidavit just now.
Just now, Lordship.
This is a case where the selection process was completed, but
Huh?
thereafter they have cancelled it without any reason.
Paper may be taken up along with the affidavit tomorrow or day after tomorrow, any day. Just now I have filed.
And let it be the month of May 6th, or so. So you will have to seek a response.
It is submitted that it is submitted by the learned counsel for the parties that the pleadings are complete.
We will have to give a response to the
No,
affidavit
in
filed
that
by
case, Mr. BD Das, learned senior counsel, assistant by so-and-so, and counsel for the petition, submits that. And affidavit, he has received the affidavit in opposition filed by respondent number,
the director had
two. Respondent number 2.
today.
On behalf of respondent, I have already filed affidavit.
Therefore, I would like to file reason by affidavit for which we first for adjournment of the matter. for 3 weeks. Mr. T.J. Monte,
Respond number 5, my lord.
Senior Counsel, Assistant Director.
A Borua.
Appears in stated that he has also filed the
Already filed.
he has already filed this. But he has filed the, already filed the affidavit in the office. Mr. A.R. Tabilda, State Council,
Higher education.
higher education is filed. Where the next prayer, Mr. Council is accepted, list after 3 weeks.
Let it be on 6th, my lord.
May I plead your lordship? It matter pertains to the non-payment of family pension, lordship.
Family pension, yes.
Last occasion, respondent was asked to obtain instruction, lordship. Respondent was directed to obtain instruction.
Yes,
Sir, I'm on behalf of respondent number 2, 3, 4, and 5.
yes.
They we didn't obtain any extra copies.
No,
We have already-
already.
Again, same time, same order on 10th of March.
They had earlier, my lord.
You have directed to furnish the copy.
Yes, my lord, they had
You
said
have
that,
undertaken,
yes,
you
yes,
have
my lord. Yes,
undertaken to furnish the
my
copy.
lord, what happened, my lord, they had said that they did not receive the copy, my lord. In fact, my lord, we had earlier, my lord, we had sub copy, my lord, on 10.
So why you are making unnecessary issue of this? Submit,
Serving is. I'll serve.
furnish it what's there.
Yes, yes, I will serve.
MS so and so learned counsel for the respondents. Submit that. He is yet to receive the extra copies from the learned counsel for the petitioner.
Within 2 or
Although the learned counsel had given an undertaking on 10/0/1003/2024. Considering. No. This court wish that such an issue should not be raised before the court. As the same is in between the learned counsel for the parties. Mr. Hub. On the submission of Mr.
yes, sir.
S. Hub, learned counsel for the bill, leave this matter up to 4 weeks. So as to enable him to furnish the extra copies.
Right.
Public.
Lordship, this petition was for assailing the impugn order dated 31/10/2019, removing my guardian from the service of the bank. Removing my guardian, late employee Hogan Sharma, from the service of the bank. So we have challenged that impugn order.
Pleading is completed.
No, not pleading completed.
Not Mr. So and so, learned counsel for the bill. This is service complete.
Service complete.
None appears for the respondents. List after 3 weeks. In
I
the-
have another submission, Lordship.
In the meantime, the respondents may file their response.
Lordship, I have another submission. Kindly see the order dated 2nd December.
It's okay, what can we do?
Uh,
It's a removal from service.
No. They are
We
in
need a
they
response.
they are on an interim, Lordship.
Interim order shall continue.
No,
If any.
that has not been released. 3 components. May I read
It's
the?
okay, the respondent, what can we do? There's a direction already.
Yes, there is a direction to, Lordship, considering the same, the respondents are directed to examine the same and disburse the amount which is due to the late employee to the petitioner as per the relevant admissible rules within 45 days from today. So then we have submitted the order of this honorable court on 9th of December. Then on 8th of January, the respondent bank has issued a letter to me referring to this order to submit certain documents. And accordingly, I have submitted all the documents on 24th of January. And then till thereafter, I have served another reminder but till that, my benefit has not been released.
File a contempt. We'll call
Can it
them.
be reflected, Lordship?
File a contempt, call them. We'll call them.
Can it be reflected in the order?
It is submitted by learned counsel for the petitioner that the respondent authorities has failed to comply with the order passed by this court on 02/12/2024. Not listed, as this court has directed to examine the claim of the petitioner and disburse the amount which is due to the late employee to the employee of the petitioner as per the relevant, due to the late employee, to the petitioner as per the petitioner within 45 days from the date of the order. He submits that despite submission of relevant documents, the respondent authorities have failed to comply the same. Next paragraph. Needless to observe that the petitioner may take appropriate steps as may be permissible under the list of. At the same time, the respondent authorities then in the non appears for the petitioner despite the service up in the beginning. Third so and so, then you write non appears for the person despite the service of notice. And no restriction. Then do all these submissions and then you should the respondents to ensure that the order of this court, that is 02/12/2024 is complied with before the next date of listing. Is the matter after 3 weeks. Deeply obvious. Yes, good.
In this case, respondents are supposed to file their affidavit, Lordship. On 2 occasions, they had tried for
Lordship.
crime law.
Lordship, we need to file affidavit in this matter, Lordship, but instructions is awaited, Lordship. It's yet to receive. Kindly
Last
grant-
chance.
Yes, ma'am.
Lordship.
Not last time, 2025.
Lordship only.
Mr. Soin, counsel for the petition.
Lordship.
Miss MS
Talukdar,
Talukdar, learned state council
State Council.
is granted further 3 weeks time to file. affidavit.
If not on your Lordship, by granted a date, Lordship. Takes a date, Lordship.
What is the matter?
Lordship, in this case, we have challenged the input order of punishment penalty of 2 increment, Lordship, without cumulative effect, Lordship. Without following the due process of law, Lordship.
Deeply obliged,
Date,
Lordship.
Lordship. My lord, page 49, your Lordship will see, I have not received the family pension. Page 49, the executive engineer department, annexure O, your Lordship. Department wrote to the accountant general.
Yes.
Lordship, now,
In this matter, the state government was probably directed to obtain instruction. I'm appearing for the office of the accountant general. I have received the instructions.
Yes.
My instruction is that, my lord, at the time when the PPO was issued, he had shown an affidavit stating that she is not interested in the pensionary benefits because she is going to marry for the second time. And as such, she had left the daughter under the custody of the brother-in-law, and thereafter she had also issued an indemnity letter of relinquishment, my lord, stating that she is not interested in the pensionary benefits. As such, the PPO was issued in the name of the minor daughter under the guardianship of the brother-in-law. That is my instruction.
Oh, no, my lord, that is.
I have got
actually
the-
correct.
I
My lord,
have got
accountant
the letter.
general taking such a statement, my lord, kindly see, nobody is there to receive the money. Brother-in-law died, husband died, my lord. Only minor daughter for last 5 years without pension, financial distress is the wife, my lord, widow. I am a widow, my lord. The act provides, my lord, pension rule that the wife is the first one to receive the family pension.
He had relinquished it. I've got the affidavits and
They,
Have you not remarried?
No, no, my lord, that is the accountant general, lottery will
No,
record
they'll-
the,
they'll-
Yes, yes,
why
lordship
they-
will go
why
through
they-
the
why they
affidavits,
should
my lord.
Make such a statement.
kindly see, my
Without
lord,
the
please.
record, no, forget about it. Why they should make such a statement?
My lord.
Why they should make such a statement?
Why they are
What could
making,
be the
because,
reason?
because some mistake they have committed, my lord, erroneously, that is the thing.
You bring on record.
No,
You
no,
consider.
I've got the written
And your
instructions.
lordship will see,
I'll file my affidavit.
from year 23, my lord, department is writing to them to correct the pension order, only correction of pension order. Not doing, my
It
lord.
cannot be done in this manner, my lord. It has to be reprocessed.
So
again.
you have no issue with the department. Your problem is with the accountant general.
Yes, department is.
Okay, heard Mr. Very serious.
And-
T. Barua, learned counsel for the petitioner. Mr.
B. Sharma.
B. Sharma, learned standing counsel for accountant general, submits that he has received the instruction. Therefore, prays for some time to bring on record by an affidavit. Prayer is allowed. List after 3 weeks.
4 weeks, my lord.
Date may be
Huh?
fixed, my lord.
After 4 weeks.
Date may be
When
given.
you have received the,
My lord, I have received it, but let it be 4 weeks, my lord. I'll file it invariably.
Immediately, my lord, after due vacation.
4 weeks.
Much obliged.
Immediately after due.
Okay.
She may get it, but the matter has to be processed by the parent department. We cannot do it on our own.
Let them do their duty, my lord, the other will.
Once the papers are forwarded,
Once they will see.
Yes, yes,
Yes, there is a complication.
yes.
Once that is on record, as per the rules, these are the things which can be allowed. Again, you have to reprocess everything.
reprocess.
We have deposited all the
What is the age of the daughter, minor daughter?
minor, my lord.
How-
16, my lord.
16.
And the thing is that after marriage, my lord, the widow will not get anything, my lord. That is, daughter has also filed one affidavit. I have no objection. If my mother get the, that is the thing.
We'll see, we'll see.
Well, a date may be given, my lord, after vacation.
After 3 weeks, 4 weeks. 3 weeks, 3 weeks.
Because financial distress, my lord, that also.
So you once, I mean, assuming that
No, no, my
at
lord.
one point of time, you abandon the daughter, you relinquish everything,
No, no.
on the hope of something better in life. Why not saying anything more than that? But we'll see.
Only that my money is lying in the account and nobody could, my lord.
Whether it's your money or whose money, we'll see.
Even daughter money also cannot be taken, my lord.
Yes, we'll see. We'll see.
All right.
May I please, Lord?
Yes.
Lordship, matter regarding the composition department, Lordship, similar matter already disposed of. Report from the Lordship.
Huh?
Similar matter already disposed of, Lordship.
What is the matter?
It is composition department, Lordship.
What is your claim? Okay, by the DLC. Huh?
Particular office memorandum. OM, Lordship.
Same order. We'll just record this facts, huh? Heard, Mr. Who?
Equitas, Lordship.
Huh?
Equitas.
Ekedas, learned counsel for the petitioner. And
On behalf of standing council of
you
Animal
agree?
Husband- I Kotoke, on behalf of MM Kotoke. You agree?
Kotoki, learned counsel for the
Animal husbandry report.
understanding on animal husbandry and veterinary department.
Veterinary.
And who else? Huh? Principal secretary. And MS Swain, Equital the state council for state response, huh?
Send back to DLC na ki. Huh? কি কৈছে?
Similar matter already disposed of.
সেইটো কি কৈছে?
Next one. Challenge made in this petition
কি দিছে?
What to say, this is a TLC present.
is to the office memorandum dated 18/09/2024.
OM to can be deposed.
Huh?
OM to can be deposed.
কি কৰিলে?
What is office memorandum? Where's the office memorandum?
Page number 58, Lordship, 58.
Issued by the Commissioner and Secretary to the Government of Assam, Personnel Department, same, Same. Whereby it has been decided that no cases for appointment on compensable ground to the family members of the state government employees who died in harness or retired prematurely or been declared permanently incapacitated for service or missing and whose whereabouts is not known prior to 31/07/2017 shall be entertained by any administrative department, public authority for any reason whatsoever, nor be placed before SLC, DL, public DLs for recommendation candidates for appointment on compensable ground. The case of the petitioner, in brief, is that his father, late Abdul Jabbar Mazarbuya, while serving as livestock inspector in the Department of Veterinary and in the District Animal Husbandry and Veterinary Officer, Hailakandi, had died in harness on 12/01/2017. Mr. You are the son,
Yes, Lordship, husband of the
being the dependent son from being the dependent son, having lost the single bread earner. He submitted an application on 16/03/2017 for appointment on compensable ground before the District Animal Husbandry and Veterinary Officer from Hailakandi. Next paragraph. Upon receipt of the application for appointment on compensable ground of the petitioner, initially the district level committee rejected the claim of the petitioner due to non-availability of vacancy in the department. Agreed of such rejection, the petitioner approached this court by a writ petition being WPC 526 of 2018, which was disposed of on 18/11/2022, directing the custom authorities to consider the case of the petition as per clause 15 of the form dated 01/06/2015. Pursuant thereto, the respective authorities, particularly district level committee, meeting dated 19/09/2023, recommended the case of the petitioner to the post of UB Constable Mr. Next page. It is the intention of the petitioner that before the recommendation of the DLC could be considered by the state level committee in terms of the office memorandum, in terms of the relevant office memorandum. The implement office memorandum dated 18/9/2024 has been issued. Where a decision has been taken that no cases of for compulsory payments shall be considered by the SLC public DLC, which has declared the right of the petition for appointment in compulsory grant under the relevant office memorandum public policy of the state. Next period. The another concept with the parties without arguing the merit, or the matter on merit, fairly submits that this court in a similar cases in this petition, so and so, within bracket so and so, Abdul Jabbar Post or something like that, has disposed of the writ petition along with other batch of writ petition. Therefore, the case of so and so strongly covers the case of the present petition. Such principle and have read this will be present petition we did by providing a similar relief as provided to the writ petitions in those in the about writ petitions. Next, then you having considered so and so, huh? Same. It's a single that
Yes,
which you have done. According to the representation. It's here, huh? Abdul Qadir Das.
Also same one. I have challenged the office, said office memorandum.
Your father's
Father's malad,
your son,
son malad,
your son, Forester.
forest department malad,
Continue this.
and died on
Same,
14/4.
Only the effects will be different. No? 85, 86. Year 85, WPC 5873 2024 is father was serving as that father was serving as
Forester malad, forester,
Forester dash 2. Command under the administration control. Forest department or
forest department malad.
under the division forest officer, Sirang division, Kazelgaon. In the district of Sirang, BTAD, huh? Who died on 14/4/2013. Application submitted on 16/05/2013. The case of the petition was forwarded to the Principal Secretary, huh? Bodoland Territorial Council. No, forwarded, placed before the district level committee by order dated 27/05/2016. However, no consideration was made by the district level committee. No information, the petitioner had no information as to whether the petitioner was, the case of the petitioner was considered. Or, against that, being agree, petitioner approached this court, being WPC 2832 of 2019. And the same was disposed of on 1505 directed the case of the petitioner to be placed to consider it and directed the respondent to place the case of the petitioner before the district level committee, if not placed earlier. Mr. The case of the petitioner, however, rejected by DLC meeting dated 18/11/2016. The petitioner again challenged this said rejection in WPC number 409 of 2020, whereby this court by the order dated 26/08/2021 directed the respondents to consider the case of the petitioner afresh. Mr. Thereof, pursuant to the DLC in its meeting held on 20/09/2022 recommended the case of the petitioner and forwarded sent to the state level committee. No, your case has been rejected.
My lord, rejected, but subsequently OM has been published, my lord.
No. Then,
That therefore, sir, I approach.
sorry, this cannot, this will be considered differently.
No,
Whether
my
your
lord.
case
But
can be rejected.
SLC rejected, my lord.
SLC
I have
rejected,
challenged that order, my lord.
so we'll consider
And
differently.
In
Will
that, my
on
lord,
its own
common-
merit.
my lord,
No, that order 18/9
my lord.
will be applicable where the case has been recommended and pending before the SLC. Right?
My lord.
And in the meantime, there as this office memorandum,
Subsequently, my lord,
it says that no cases will be considered.
consider.
It has not been interfered with. Now your case has been rejected by SLC. We'll consider it. Just forget it. Or cut. We'll consider it. You file the affidavit.
Right.
It's not, and you have not challenged that order also.
My lord, I have
Office
challenged,
member-
my lord. I have challenged that
Where
SLC
it
order.
is?
My
No,
lord, kindly see prayer, my lord.
you cannot. Once your case is rejected by SLC, cannot be.
Impute minutes of the meeting of the state level committee, my lord, page 21, prayer. my lord. On compassionate ground on 38/8/2024.
It will consider differently. Your case has been rejected by SLC.
Subsequently, my lord, OM has been published, my lord.
This court has directed it twice. Placed before, so it's placed.
My lord,
On its own merit, we will consider.
My
Not Mr. K.R. Patgiri, learned counsel for the petitioner. On the prayer of so-and-so, learned counsel for the petitioner, list this matter after 4 weeks. So as to enable the learned state council to file the affidavit. Huh?
my lord.
Same,
86 also, sir, my lord.
SLC rejected.
SLC.
Whether the rejection is bad or it's as per the law, we'll decide that.
My lord.
Because 18/9/2000 today has not been interfered with.
My lord.
That will be applicable for the cases where the consideration is pending before a DLC or SLC. In that case,
I will satisfy.
I don't know other cases,
My lord.
I mean. Patgiri, normally I believe the lawyers, whatever you speak out is keen or is as good as the gospel truth. Otherwise, this should be a miscarriage of justice. Yes,
I'm sorry, Lordship, I wasn't late in another court. This requires.
item
32, your Lordship.
That over matter.
Huh?
32.
32,
Yes,
yes,
your Lordship. Lordship, kindly peruse the order dated 21/6/2024 for
yes.
24, your Lordship.
Have you received the?
No, we have not received anything, your Lordship. Whether he's
What is
attending,
this?
attending his office or not, even he has not produced anything before us, your Lordship.
Huh?
Because as per last order, your Lordship, kindly peruse the last order 21/6/2024.
Yes, read para 5.
According to
appear
court is
before
inclined
the
that the
central
petitioner shall appear
Hmm.
before the Central Checking Range Officer Chief Conservator Forest at 10 a.m. at 26/6/2024
Yes.
and have his presence recorded by the range officer. The said authority directed that on presence of the petitioner, he shall record the presence of the petitioner and provide him with a written certificate of his attendance, simultaneously copy thereof provided to the Senate Council, along with the comment as to whether the petitioner has been attending the office or not. Also, first he has to come and appear before the office. Whether he has come or not appear, even he has to produce a document, Lordship, because at para 6, the same document shall be produced by
What
both
he has
sides.
said is he appeared, but no certificate has been given to me.
So let him put that on affidavit whether he has appeared or not. And
So
he is
what about-
dismissed. He's been
what about you?
dismissed.
Have you issued the?
He's dismissed from service, your Lordship.
Huh?
The petition dismissed from service.
No, my lord, the department, they have so cause not to issue, so I replied the department person is pending, not yet initiated, my lord.
Whether he has gone to the office or not, he
Yes,
has to
today
come with a
also, my lord,
document to prove that.
I am here, dear, my lord, in the office, my lord.
And
Today
further,
also.
this writ petition is filed the same cause of action. He didn't take a
Okay,
liberty
no,
with that.
that is another aspect. We'll just first complete the issue on this para 9, para 5. Paragraph 5 says, have his presence recorded by the range forest officer. The authority is directed on appearance of the may, it says he or she shall record the presence of the petitioner
Hmm.
and provide
Provide
him
him
with a written certificate
Yes,
of
Lordship.
his attendance.
And simultaneously be a copy
A
of their.
copy thereof be provided to the learned standing council along with his comment as to whether petitioner has attended the
That
office.
copy has not been provided to us, your Lordship, till date.
Then how, on what basis you are submitting now?
Because as per my instruction, Lordship, first and foremost, this
First
mandatory.
instruction you have. Maintainability where that you have already submitted.
Yes, your Lordship.
That after that only this order is passed.
Thereafter, this order is passed, your Lordship.
So
Let it come on Friday, your Lordship. I'll take the instruction whether he has
Friday.
been Friday.
you are also have the equal duty. Equally, you have the duty to produce.
My lord, I'll pray for my lord, my.
Why you are saying that he has been already dismissed?
Because as verbal instruction, Lordship, I have been received from.
Get it written.
I have
You
to-
just
I
get
get- I have to get the
this,
dismissal order also,
certified
my lord.
Copy of this order, last order. And send it to them.
Very
Next
well.
Friday will either this way that we are disposed.
Very well, Lord.
My lord.
And if he has dismissed,
No issue,
What-
that
what's
not maintainable repetition, my lord, we are
if it is
dismissed from service.
dismissed, Mr. Serena.
No, my lord,
Will think
today also I'm in office,
you
my lord,
think-
at
think
morning
of
he called up me,
imposing
my
a
lord.
cost on you.
My lord, not dismissed, my lord, no proceeding happened, how they can dismiss me without giving me notice,
Because of
they are
this,
doing
we have
departmental
spent
proceeding.
a considerable time. So you be fair.
My lord,
We'll take a look.
my lord, not dismissed, my lord, that may be reported,
take
my
that
lord, my lord,
submission.
final
Just don't
submission.
make an instant submission. When the
Lordship, I
person
just
is
feel
in
purpose.
service, I mean, maybe in under suspension. How can you just dismiss like that?
No departmental.
I'll take the complete instruction Friday, Lordship.
Friday.
Friday.
No
Friday.
adjournment.
No adjournment, Lordship.
My lord. I'll also, my lord, make an application that I have still in continuing office, my lord. That
Not
I'll
only
make an application to
you
provide
have
me
to
that
show the, you have
certificate.
to obtain the certificate.
My lord, my lord,
Otherwise, we'll help against you.
My
Against the council for contempt.
my lord, my lord,
For violation of this order,
my lord. My lord,
not the petitioners.
My
or
lord.
the respondents.
Obliged, Lord.
I love you.
Friday, Lordship.
As agreed to by learned counsel for the parties, Mr.
I'm sorry. Your Lord.
M. Serenia. Learned counsel for the and Mr.
R.R. Gogoi.
R.R. Gopal. Standing counsel.
Standing counsel.
Forest
Forest.
Department. List this matter on 11/04/2025.
My lord,
To comply. To obtain instruction as regard the compliance with the order of this court. Passed on. What, 21?
21,
21/06/2024.
24.
I love you.
Obliged, Lord.
Yes.
Lordship, kindly pass forward the matter for typing.
How long? How long will pass over? Where is Gayan? Miss Gayan?
Lordship, this is in port number 21, Lordship.
Ah. So as to enable her to confirm as to whether the order for mentioned in the complaint is potentially similar issue with the previous case. What is to be done?
My submission is that it is covered by the orders of this Honorable Supreme Court and the other judgments of this Honorable Court. Issue is very simple. We are supposed to be nursing personnel in the Assam Rifles. They denied us the nursing nursing allowance at the initial stage. We moved this Honorable Court. Honorable Court held that being nursing personnel, we are entitled to the nursing allowance. They moved the division bench. Division bench upheld the orders of the Lawrence Single Bench. They moved the Supreme Court. Supreme Court upheld the orders that we are entitled to nursing allowance because we are nursing personnel. The second type of allowance which was supposed to come was the dress allowance for nursing personnel. Now they take up again the same ground saying that we are not nurses, we are only nursing personnel, we will not get the dress allowance. Just where did they stand on this? And now under contempt petitions filed in this Honorable Supreme Court, they're paying us the nursing allowance, denying us the dress.
What about the contempt petition? It has been discussed.
Well, it has been now closed because they started paying the nursing allowance. The same thing would go for the dress allowance. We applied for the dress allowance. They say you are not nursing nurses, we will not give it to you. The same logic applied for nursing allowance.
What is the order of the Honorable Supreme Court?
My lord, that we have already annexed.
Has it been in the appeal?
In the writ petition. Should find the first order which was passed by this Honorable Court is from page 34 onwards. Lordship should like page 42, paragraph 12. The respondents have filed their counter affidavit denying the claim of the petitioners. In this connection, it has been stated that nursing assistants have been specifically excluded from the purview of nursing allowance as per OM dated so and so. Although the copy of the said OM has not been annexed to the counter affidavit, the same has been produced during the course of hearing. It has been contended that the entire page 42, paragraph 12, I was reading their stand regarding the nursing allowance part.
No, they were seeking it then.
No, we were seeking the nursing allowance because they were denying it to us, saying that we are nursing assistants and not nurses. This Honorable Court held that nursing personnel of all categories, including nursing assistants, will be entitled to the nursing allowance. This was
nursing allowance and the dress allowance is something.
To the same, they are different allowances, but given to the same class of person, nurses. Nursing personnel, not restricted to nurses. A person who stands in the footing of a nurse.
No, nursing allowance is no dispute to them.
Yes.
There's no dispute.
Yes.
Then
and the other stand is that those who are entitled to nursing allowance are entitled to dress allowance. Their only logic is you are not nurses. This has been set aside by this Honorable Court. Lordship will find at page 49, para 24. Para 22 onwards, para 22. Page 49. The office memorandum referred to above do not make any distinction between the nursing staff with diploma and certificate and the nursing staff without such diploma or certificate. Had it been the case that the said OM should have specifically spelled out the same, on a total reading of all the OMs, there is no escape from the conclusion that the nursing allowance is applicable to all nursing personnel and staff. The respondent themselves have admitted in their counter affidavit that the nursing assistants form an integral part of the nursing staff, but at the same time have stated that the same will not itself qualify them for grant of nursing allowance without, however, specifying anything as to why they are not entitled to the same being an integral part of the nursing staff. The expression personnel means for people employed in an organization or engaged in organized undertaking. The expression used in various OM is nursing personnel who are entitled to nursing allowance. In the said OM, no distinction has been made on the basis of qualification, etc. All pervasive expression used in the OMC is that the NA will be applicable to all nursing personnel working in the central government hospital. Then Lordship should have page 51. I'm sorry, my lord, the last lines of that very paragraph. I'm reading from the fourth line from the below. Various categories, including the nursing assistants. When the OMs themselves do not make any distinction on the basis of educational and professional qualification towards entitlement of nursing allowance. In my considered view, the authority of the Assam Rifle cannot import something to the state going to deny nursing allowance benefit to the nursing assistant. For the aforesaid reasons, the pair of the petitioners in exceptions of the petition is allowed. Then they went up in a writ appeal to say that nurses and nursing assistants have different educational qualifications and therefore they cannot get the same allowance. Their lordship will find at page 59, para 21. The service rules, lordship has it. The service rules above do not prescribe any special qualification for recruitment of nursing assistant, unlike sisters, matrons, etc., who are to possess special qualifications in the term of recruitment rules or service rules, and therefore the nursing assistant cannot claim any allowance applicable to the nursing staff under the office memorandum aforesaid. This was the argument of the respondents. Then lordships will find at page 62, 30, para 32, how it was dealt with. Lordship has the page 62, my lord.
Supreme Court.
Supreme Court order is there are two lordship will find. By order dated 9/9/24, we had directed 4 weeks time to the alleged contemners to comply with the orders of the High Court, which was confirmed by this court. It is informed that the allowance for the month of September has been paid. We do not appreciate the conduct of the alleged contemners in paying only 1 month allowance. Period of almost 10 weeks has elapsed from the date on which the directions were issued. So and so, so and so. Then lordship will find the single sheet that I had given. Their communication to the Honorable Supreme Court. Para number 2, it is intimated that nursing allowance has been granted with salary bill of September 2024, which was stopped erroneously. Balance area will be paid in respect of affected persons will be passed in on receipt of area bill from individuals or units concerned. But thereafter, the bills have been paid for the nursing
According
allowance.
to this, nursing allowance will also falls under dress allowance.
Now, lordship will have page 29 of the reflection. This is where the dress allowance which we are seeking now was started. Dress allowance to the nursing personnel, lordship will find it is nursing personnel implementation of the recommendation of the seventh Central Pay Commission, consequent upon the decision taken by the Government of India on the recommendation of the seventh Central Pay Commission by Ministry so in supersession of the existing orders relating to uniform allowance and washing allowance, which have been subsumed to a single dress allowance. The President is pleased to decide the rates of dress allowance at the rate of so and so in respect of nursing personnel of Central Armed Police Forces, Assam Rifle and National Security Guard eligible for it. Similar to my lord nursing allowance, this order says that nursing personnel will
So
get
you
the
have,
dress
you
allowance.
have been denied
Now we are not being paid because we are.
because you
nursing
have a different, the qualification.
So they say that we are nursing assistant, we do not fall in nursing personnel because we do not have the nurse's certificate. That was decided already by this honorable court in the earlier judgment saying, nursing, when the office memorandum says nursing personnel, there will be no question of the educational qualification. If you fall
There
in
cannot be
the,
distinction.
there can be no decision. Therefore, we
Nursing personnel includes all.
nursing assistants and sisters and matrons and nurses, and therefore everybody would be entitled. Now, since that was a judgment passed only with regard to the nursing allowance part, they again now are taking a chance saying that, no, we go against that judgment, that finding, and we say that, no, you will not be allowed for the dress allowance. And that denial on only on the basis of the educational qualification is also there in Lordship's page number 67, page number 2 of their affidavit in opposition, where the specific stand is.
No, where is the order confirming the High Court order?
That I have. I'm sorry, I did not consider this.
They filed the affidavit taking the distance.
Yes, that
Then
only
it is-
because of the educational qualification, we will not
case-
give it to you. Very short order passed by the Honorable. Delay condone, no merits.
Where is question of law?
That they could never answer, they never raised the question of law, and therefore the contempt petitions came up when they did not give us the nursing allowance. Pursuant to this order, the contempt petitions were filed in the Supreme Court. They are page 2, para 5, madam.
Affidavit.
My lord, yes, of the affidavit.
It has been answered in the earlier proceedings.
Which one, madam? Yeah, this has been answered. That is the only ground they are taking up again and again.
Office memorandum 2013.
They are taking up the same ground again and again to deny us the allowances every time. And in their affidavit, Lordship may like to have a look at page 79.
This 29 January 2013.
29 January 2013.
Yes.
That is a
office
page.
memorandum.
It's page 78 of their affidavit.
There has been settled payment of nursing allowance to the nursing personnel of
CPF at the rate applicable to nursing personnel of the central government hospital. The undersigned is directed to state it with partial modification of this ministry's order of event number dated 28/7/09 on the subject above. Para 2 will be read as under. All nursing personnel are eligible for nursing allowance as per Ministry of Health and Family Welfare dated 28/7/1998.
This has been interpreted. This has been.
No, they have been trying to interpret it again, saying that.
No, this has been earlier occasion, this court has interpreted.
13,
this. Yeah.
13 not madam. Because the order Lordship will find, or the first order came in 2010 Then the division bench order came in 2011. And the Honorable Supreme Court, if I'm not wrong, the order came in 2013. Though this was the very logic place before all the honorable courts, the honorable courts have rejected it. And the original office memorandum is not of the Ministry of Home Affairs. It was an office memorandum of the Ministry of Health and Family Welfare. The Home Affairs tries to amend it. But again, they come back, Lordship will find it page 79. They again remove it. Page 79, Lordship will find. Consequent upon the decision by the government on the recommendation of the 7th Central Pay Commission, which I just read out, madam. While Ministry's finance so and so, in supersession of the existing orders related to uniform related allowances, uniform grant kit so and so, which have been subsumed into a single dress allowance. The President is pleased to decide the rates of dress allowance in respect of personnel of CAPF, Assam Rifles, so and so, as under.
So you are also claiming the same.
Yes, we are simply saying that since it's a dress allowance which is applicable to all nursing personnel.
They have been subsumed into a single dress allowance.
Yes,
And there's
earlier
no-
we got.
There's
earlier
no
it was-
longer nursing allowance.
No, nursing allowance is a separate thing. That is because we attend to the patients. Dress allowance is what we get for wearing our uniforms, washing our uniforms, which get blood stain, which get medicine stain. For all these are now subsumed into one, the dress allowance.
Instead of maintenance allowance, nursing allowance.
Yes,
And granting kit. Granting kit.
kit maintenance, I need to carry my cotton and everything. All these things are now subsumed into one, the dress allowance.
Yes,
They deny us that.
madam. You have denied them earlier,
Yes,
even
sir.
the nursing allowances. And this
Now-
court has said that they are entitled and it has been affirmed by Supreme Court,
Yes, ma'am.
right? Nursing allowance.
Yes, ma'am.
Now,
Now the
this
issue is
present
dress-
case, there is a dress allowance.
Dress allowance, my lord.
You are having the same, almost the same ground. That since you have since they are not having the qualification, there is a difference in qualification and
Yes.
training. They are not, but then it's almost same thing. It only talks about the nursing personnel.
Yes, nursing person, that is the different nursing personnel, my lord.
So that nursing personnel has already been interpreted by the court. That it will also include the nursing assistant. It has been affirmed by the Supreme Court.
My lord, that is.
But then it was Guwahati High Court, Meghalaya Shillong bench.
That is by my lord is 64.
5350.
Yes. Last occasion, you were directed to
Yes,
look
my lord.
into.
I have gone through this order of the Supreme Court, my lord, that is regarding the contempt case, contempt petition
It's
number.
okay. Huh.
So in the contempt petition, they referred that SLPC number 12334, my lord. And I have gone through that order also, but I didn't find the fact of the
No,
case.
it has been dismissed.
Yeah, dismissed,
It's
yes, my lord.
arising out of this case only.
All were one batch, all came up together, madam. Now.
Huh?
That is arising etu pra ahise bole ahise negiditu, Kumar.
Is it
It-
contempt is arising out of this case?
That I have to check, but that's why that is. My lord, writ appeal, kindly see the special leave appeal, my lord, arising from the impugned judgment 31, 256, 14, 15, 257, 16. There is no mention about that this case, my lord. Arising out of the court order, my lord, arising out of impugned judgment on order dated, my lord. That is not there.
I'll just sort it out. Lordship should have the matter tomorrow. I'll give her a booklet marking out on highlighting every of the cases she needs to know.
Yes, my lord.
Lordship will
Tomorrow,
have it
yes.
tomorrow. I'll have it too.
Tomorrow, my lord.
Tomorrow. We'll keep it for her after
Yes,
vacation.
ma'am. After vacation.
There's no urgency. After vacation.
Yes, ma'am.
We'll keep it for her.
Yes, my
Let
lord.
her it enough.
Yes, my lord. Part heard, my lord.
This is second time.
Yes, ma'am.
Our Mr. Or Majumdar, none counsel for the petitioners and. And it's, yeah, none is. This the matter after 2 weeks.
Part heard, consider of it.
Yes, part her. In the meantime. What is to file there? What is to be filed? Compilation or? the-
Compilation of all the
Compilation.
synopsis of all the.
Synopsis. What, huh? Because it's very difficult to find.
No, I'll
Yes,
get it on one.
2 weeks. Make it 3 weeks.
Master.
Yeah, please, Manoj. As promised, Manoj, not more than 5 minutes I'll take, and all these 18 matters can be disposed of.
Ah.
If I can just explain in 2 minutes what was the grievance in the petition, Manoj.
No,
and I
no,
would
that's
say,
I've understood.
with this division bench's order, Manoj, the grievance stands satisfied. Therefore, Manoj, the suggestion that I'm making for my lord's kind consideration is after division bench.
No, we'll not go into now. Yes, Mr. Majumdar,
My lord, yes.
you have said that the petitioner is being considered. Their verification are being taken.
Yes, we are going, undergoing to
So
take
if
verification
you
of
are
that.
allowing them, what's the use of?
No, my lord, they, whether they are to be considered for appointment or not, on the basis of the orders. Because the first sentence that I found in the writ petition was, they are relying on judgments of the Honorable Supreme Court saying that this is the review order, this is the orders passed. Their writ petition starts with this sentence saying that the JV's judgment is not applicable to the state of Assam.
Huh?
That judgment, the original judgment, is not applicable to the state of Assam is how they start their writ petition.
Who?
No, the answer.
The
to
writ
that is
petition.
The writ
Yeah,
petitions were filed prior to the clarification order. When the judgment, original judgment came by which they disqualified me, the writ petitions were filed after that. Thereafter, during the pendency of these writ petitions, the Honorable Supreme Court on 10th December 24 has clarified that what my original order was not to devalidate or de-recognize the course. And after 10th December, 4 times, even 2 days back for state of West Bengal, they have passed a judgment, Honorable Supreme Court, where they have said that both these courses,
Then why don't you approach the Supreme Court?
well, the reason that is this. All those states, West Bengal, Bihar, Uttarakhand, etc., the high courts had given a judgment prior to the clarification and against us. Now, this is the only state, Manoj, in my humble submission, where the matter is sub judice when the clarification has come. So therefore, all those states, which in fact, some of the states I had the opportunity to represent, we challenged the High Court's judgment holding against us, saying that they are misconstruing Honorable Supreme Court's order. So therefore, the Honorable Supreme Court has set aside all of them, saying that West Bengal, Bihar, Uttarakhand, whichever went there, whatever the High Court has held was is erroneous, is what the Honorable Supreme Court says. And finally, what they have said is that both these groups, that is 24 months vis-a-vis 18 months, are at par with each other. In fact, here in Assam, we are at a better position because there is no appointment. Wherever there was
But then
appointment,
wrongly or rightly,
Lord,
they have debarred you and they made you ineligible
indeed, my Lord,
because of 18 months.
indeed.
Right, 18 months, right?
Yes, the state made.
So why don't you approach the Supreme Court?
The answer to that is this, thoughts. Once they debarred me, they passed a circular on 2nd January 24, relying upon the Honorable Supreme Court's order. That circular is the subject matter of this writ petition, where I am seeking a quashing of that circular. During the pendency of that writ petition, the clarification has come. Now, for any reason, my lords, if my lord had to, of course, now there are 3 orders which they are bound to follow. It is an Honorable Supreme Court's order. If for any reason this writ petition is not allowed, saying that yes, the 2nd January circular,
See,
yes,
they have relied on the Supreme Court judgment.
subsequently it has been clarified, which they have not taken.
Then you approach the Supreme Court.
Unless the answer to that is this. If it has been clarified subsequently for whichever there was a negative order, my lords, before the Honorable Supreme Court, and that is, if I can just show that for three states, I will take 1 more minute each. The problem is this, my lords. Now they have given a concession before the Honorable Division Bench, saying that I will be considered. If I will be considered, the 2nd January 24 notification, which is the subject matter of this writ petition, has to go, because that is the only hurdle. That's point number 1. They also gave a statement before the Honorable Division Bench that I'll be considered for the present 26th December 2023 advertisements. My second grievance in the writ petition also stands satisfied. So all that I am seeking is that on the basis of those two statements given by them before the Honorable Division Bench, the writ petition may be allowed. That's point number, that these are the 2 points. There is also a third point. The third point is this, that all these 4 judgments that have been passed by the Honorable Supreme Court in Bihar, Uttarakhand and West Bengal, laying down the same principle, they have extended the benefit of consideration only to the petitioners / appellants before the Honorable Supreme. So therefore, the third request that I'm placing for my Lord's kind consideration is that the writ petitioners before my Lords are about 1700 in total. So the consideration by them for this recruitment of 26 December 2023 should be only restricted to these petitioners as laid down by the Honorable Supreme Court in those 3 matters. Now, for me to go there, my lords, I need a negative order. And any person approaching the court, my lord, would believe that we'll get a positive order before this court. Specifically, my lords, when those orders were passed there was no clarification. Hence, the Honorable High Courts in various states followed Javeer Singh and said that we are not eligible. But once we went there and we said that, yes, this is...
That's why you go again here.
My lords, by that time, can I just show that these 2 orders, maximum 1 minute, it will be completely clear. Can I just show those 2 orders?
I'm clear.
My lord.
Why I'm not clear is why you are not approaching this.
My lord, we don't have a reason to go there for now because the matter is sub judice before my lords, and my lord's kind indulgence on the last hearing.
Grant you a liberty, close the matter, with
Can I-
a liberty to approach the Honorable Supreme
If
Court,
my lord can
because-
just have,
Because the matter has been decided by the Honorable Supreme Court and it has been clarified. Why don't we approach this?
my lord would just have one order with me for a minute. In fact, my lord would just have an order of passed by this honorable court on 10th February 25. 10th February 25 in this batch of writ petition, there is an order passed. The order simpliciter says, I will not trouble my lords to go through it.
No, read it.
Yes. My lord, this order says, the petitioners, by way of instituting these batch of writ petitions, have raised the grievance with regard to the prescription of qualification in the advertisement dated so-and-so. The fundamental ground of the petitioners is that in terms of the determination made by the Honorable Apex Court in order dated 10/12/2024, passed in review petition so-and-so arising out of so-and-so, the petitioner's qualification of DLED is being recognized. That is the grievance that is recorded. It is further contended by the Learned Counsel for Petitioners, that is us, in terms of the aforesaid determination made by the Honorable Apex Court, the competent statutory authority NCT has also recognized such qualification which is acquired between 22/9/2017 to 31st March 2019. And accordingly, a notification has been issued. It is further the case of the petitioners that they have acquired their qualification during the aforesaid period and therefore their candidature should be considered by the selection committee. Mr. So-and-so, Learner Standing Counsel for the Education Department, Assam, submits that they may be allowed some time to respond to such contention. So therefore, and finally, these matters were to be listed on 18th March. So therefore, an IA was filed that now once the Honorable Supreme Court has given a blanket order saying that every state needs to comply with my clarification, why is the state of Assam not complying when state of Meghalaya has done it? All other states have done it. It is only state of Assam not doing it. So therefore, an IA was filed here. On that IA, this order is passed, saying that once there is a clarification which is blanket, which is not specific to one state, you should please apply the clarification and the basis of which your circular was issued. So the circular of 2nd January 24, which is impugned, is only on the basis of Honorable Supreme Court's order. There is no other basis. So therefore, what was argued...
According to you, that has been subsequently they
clarified. And that has been clarified.
After the issuance of this.
Indeed. This advertisement is of December 20.
After the issuance, before the issuance of clarification,
My lord.
they have issued the impugned circular.
Indeed. Indeed. The impugned circular is prior.
They filed the affidavit.
They have not filed an affidavit, but my lord, with these 3 judgments, I would submit, and therefore I am taking this.
No, I've understood. We'll go at this. Without their affidavit, how can we dispose of the matter?
I understand. My lord, their concession is recorded.
I've heard you. We'll listen. We'll hear him.
Yes.
Whatever he said. Yes.
Lord, on the last order that was passed by lordships, I was required to be given the copies of the writ petition and all, not served to me as of today by that one.
I'm sorry.
Now,
We
with that
know, we have
affidavit,
fixed the
therefore,
matter. You have approached the division.
we approached
Division
only,
bench
on-
also
no,
fixed the matter.
only thing that we received, only thing that was there before the appellate court, the
No,
appellate,
forget about it.
no, there,
But
we
whatever,
only,
what is your response?
we only.
Okay,
took
we'll
up-
give you a time to respond, file a affidavit, but then what do his response?
My lord, our
See,
response,
impugn order
they
has been
start-
issued, no, impugn order has been issued before the clarification issued by the
No.
Supreme Court.
the clarification, the first clarification came on 10th of December, if I'm not wrong.
Yes,
Our office memorandum was issued on January. So it was after the first clarification.
No.
It
January
started,
24. I'm sorry, January
Just
24.
wait, we'll hear you.
that is what that is what I remember the cases. Now, when they challenged that particular office memorandum, the first thing that they said was JVD is not applicable to us. They start the writ petition saying JVD is not applicable to us. The Supreme Court orders are not applicable to the state of Assam. So therefore, the office memorandum should go. Now there is a complete change saying that no, any clarification given in that case has to be applicable to us. What do I answer to me?
No, actually, accordingly, you answered.
And
to
now, my lord, now the
You say if it is not applicable, you said once you have said that it's not applicable, matter ends there. Now we'll consider it, we'll determine it. Now they are saying that because after the subsequent, I mean, whatever
yes,
clarification, it applies. What do you say on that?
the Supreme Court has clarified that 18 months DLED course will be equivalent to the 2 years DLED course. But still, in my humble submission, the state government has the right to find out which of the equivalent qualifications we need to choose for our selection.
No, nobody is objecting that you can, I mean.
So therefore,
you
we
can-
choose the 2 years, even then the 18 months goes. If we are choosing the 2 years, which is
No,
for our roots.
nobody is questioning your, the choosing whatever you choose, whatever
Yes.
your authority to decide
Yes.
what qualification, how,
True.
how much, what would be the qualification for a particular post. Why not on that? Today we're on that, after the judgment clarification of the Supreme Court, what would you say? Whether
We are
it
saying
applies
that-
to your state or not?
My lord,
If you, whether it applies to the state of Assam or not?
the judgments.
Yes,
If a certificate is equivalent, it is equivalent.
yes.
The Supreme Court says
No,
it is
You
equivalent.
cannot
it is
have a
equivalent.
debate. You cannot just
But
because.
then-
No,
but then whether we need-
just because you have the authority to decide
Yes.
what would be the qualification, you just cannot decide. Contrary to what is.
So that is why
passed by the
we
court.
would have to file our
have-
affidavit in the different cases, in all the cases, because there are two batches now I see. One batch which says that it applies, one batch says it does not apply. I do not have copies. I can start reading the first line.
No, let us not
Lord,
go.
we will find
Let
the
us not
first-
go into the technicalities of the pleadings. But
The exact
it's a
reading,
read- no,
reading is sacrosanct, my lord.
No, these are the only. Sacrosanct is, I understand, but then the nature of the case where, dealing with, it's a simple matter. Why are you making it complicated? If you agree that on legally, when the Supreme Court decision is something different, which cannot be made applicable in a state, you argue that.
That is what we would like to argue with our affidavit, my lord.
You just cannot have that kind of.
That Lordship should give me a week's more time, asking them to give me the copy. We'll have it immediately on the reopening, or we'll have it on Friday.
No.
I'll still try to
These
draft
are-
it up.
These are recruitment process
Oh,
just
it is-
because that day you want to hear you argue the matter. I remember
Yes. And I had also made a
because you
statement, my
had
lord,
an
that
apprehension that the process will be, staged.
stalled, yes. The process is not stalled.
No,
The
it's not.
the process. is
Now,
not-
when he made a mention this morning, I said, I'll not hear the matter. If it will take, detailed hearing,
My lord,
if that is your stand.
my lord.
But then he said, division bench is fixing the matter today.
No, division bench has said that the matter would remain fixed today. There is no
And
difficulty on that.
the division bench interfered
Division
with
bench
the interim order just because of your own statement,
No,
saying
division,
that they are being considered.
we are, my lord,
They are
we
not
are,
hosting.
we are not, there was no statement made that.
Now,
because the
issue
Constitution
is
find the order.
the office memorandum is in consonance of the decision of the Supreme Court or not. That is what.
May I just state, my lord, what was said to the Honorable Division Bench? We said that since they have applied, all applicants who have applied under the advertisement, we are going for a physical verification of all of
That's
them.
fair enough. Fair
So
enough.
there, but as of now, the documents are being physically verified, there is no difficulty.
Yes.
But that is not the end to their problems or to our problems.
No, that's why if you are objecting, we'll hear you.
That
We
is what I
don't, we
was-
don't, since you have allowed them and you have, as the impression was made by
That-
the
that
learned
interim
counsel for the
So far
petitioner
as the
that,
interlocutory,
since the petitioners have been
so
allowed.
far as the interlocutory applications are concerned, my lord, they are now set at rest because we have allowed them, we have called them for the, I'm sorry, we made a concession that we call them for their physical verification along with all other people. Any and everybody who has applied, who comes within that particular 1:2 or 1:5 zone, everybody comes to get their physical documents
Have you gone
verified.
to the judgment of Supreme Court,
Which one? Madam?
which is reliant?
Today morning, I was given a copy when I was in court number 4. I think I left it there itself. Yes, I left it there. I'm sorry, but there was a bunch of judgments which are
Decided. Forget about what is the, whether you have correctly issued an impute notice or not.
my lord.
Impute this notification or not. Maybe state might have at point of time may not have looked into it. It's you to tell them. If you legally, if it is contrary, I mean, as per the, if you have issued it, I mean,
With
use
the
your
orders,
office.
with the orders
I would
passed.
request the Advocate General and you also to use your office, good office.
Could I pray, my lord, the matter be taken up in
Not
the
with the heck
immediately?
of- See, we don't expect. I mean, maybe there may be a wrong interpretation, maybe to this court also.
I could be wrong also. my lord.
We do our, do the best of our
Yes.
knowledge only. So go for that. Let us not go into that, whether once the state has issued an order, will stick to, will have to defend it.
Not
There are
this.
cases where this, which may not be, which may be
It may not be a crime.
indefensible.
But
May
that
be
is,
indefensible.
but that
Then
is,
the way out is to advise the government.
would lordships.
And I understand, I had the experience. They'll always stick to their order, no matter how it is. You'll ask, they'll ask you to go to the Supreme Court also. If possible, International Court of Justice. If it lies. But then we'll have to
Because
advise them. I have not gone into, I have not, but prima facie, I see, I think, I see that there is something
And-
contrary.
our first opinion, which went in this case, when the first
And
time the matter
number
came up,
two- Number two,
prior to Javid. Prior to
even
Javid,
for, even for a moment, I'm not saying that you don't have an authority to decide what qualification would be required for the particular. But problem here is not that, the issue. Issue is whether your notification debarring or
Needs a-
making them ineligible
needs a little.
is consonance with the decision or of the Supreme Court, or it is contrary. That's all.
But it-
You go to the Supreme Court judgment and the clarification thereafter, whatever is there. And then look into your office memorandum.
May I pray, my lord, the matter be taken up on immediately on the reopening on the first or second day, there is no difficulty. I'll have a consultation with the learned AG also. We'll try to have the department concerned. We'll have a discussion. Lordship will have it
This
immediately
court-
on the reopening.
Seriously
by-
feel
because
that
by-
way the things can be resolved
Yes.
without having a kind of typical adversarial form of litigation. We should resolve it.
This is,
See, tomorrow, if we find that this is something wrong, we're not here to confront with anybody.
no,
Where
never,
all of us,
never.
including you and us, we all are here for justice. Indeed. To the best of our knowledge and ability. We're not against anybody.
We cannot. That is never, my lord, what-
The litigants before us is not only the petitioner. The government and the respondents are equally the litigants. So there cannot be any, I mean, kind of thing. that's-
the
In fact,
intention
but
of
the
the,
clarification order was given by the Honorable Supreme
So
Court.
in any case, Mr.
Mr. Kalra.
Huh?
Mr.
Kalra.
Kalra.
We'll fix some other day. In any case,
Because I understand what it's doing. Just consider me
we
for
thought, I have indicated you, if it requires, I'm not averse to, I mean, detailed hearing.
I understand.
But then problem is, they have not filed the affidavit, let them file the affidavit.
Let it be immediately. on
Maybe
the-
your petition is bulky because there are so many petitioners.
I understand.
But the issue is very simple.
Issue is simple.
In
that
fact,
is-
Manoj, if I can just add, just to,
I'm not saying that what
Kidding?
they should decide, what I.
no, I understand, Manoj, but with due
24th.
respect, my lords, kindly consider this.
24th or 29th?
The authority,
Rather, I'm asking the assistance from them,
indeed, my lords,
including you.
but kindly consider this submission for 1 second, my lord. The authority to fix the minimum qualification for primary teachers. I'm conscious of the time, my lords. I'll not take more than 1 minute as
No,
promised.
you are free.
My lords. The authority to fix the minimum qualification for primary teachers in any state is NCT. The NCT has recognized my course.
Having that background only,
Yes, my lord.
Having
That is
that-
point number 1.
considering and keeping that in mind.
That is point number 1.
In the background, I'm
Indeed.
deliberating with you.
Point number 2, when the clarificatory order came on 10th December 24, the notification is of 2nd January 24. 11 months prior to the clarificatory order. The clarificatory order comes later, but makes it applicable from 28/11/23. So prior to the notification, the clarificatory order is made applicable by the Honorable Supreme Court. State of Assam is a party there. I filed an application on behalf of some of the applicants
That
here.
I've heard you, you have.
Yes, my lord. So State of Assam is a party there.
Other day.
Indeed, my lord. I'm so
Okay,
grateful.
thank you.
Number 3,
So you
just
just
one
tell
last
us
thing.
when to.
Just one last
After
thing.
3 weeks.
Just one last thing.
You have been allowed, all of petitioners have been allowed
My lord,
to participate
that may be recorded,
by,
my
by
lord.
verification.
That may be recorded, my lord. All
Not
petitioners.
recorded, that's already clear. Right?
My lord,
By the division bench. Why
therein
should
they
you-
have said that respondents therein, they challenged only
Why
one.
just granting them few days, few weeks time to, or 2 weeks or 3 weeks time to file their affidavit, will dispose of the matter.
My lord, but the petitioners, that may be recorded that petitioners are allowed for the
No,
verification.
division bench.
They-
The basis of the statement of the Advocate General, London Advocate General. The division bench has
My lord,
passed the orders.
yes,
So
in the
we cannot-
division bench's order, they have said respondents herein. So the respondents there were only 40. So therefore, my lord, it shouldn't be. And all these orders that
No,
I'm
that we cannot, I cannot modify the
No,
order of
I am
the
only on this
division
point.
bench.
What the Honorable Supreme Court has said,
Sorry.
that only the
We'll see,
petition.
we'll see.
My lord, just one,
Our issue is now
please.
whether as per the Supreme Court clarification or the judgment,
Please,
whether you are eligible
please,
for this post,
please.
whether the notification is contrary or in
Indeed.
to the
For
decision.
that, just
That's all.
wait for
That's
10 seconds, see these 2 orders of the Honorable
No,
Supreme Court
you
recent.
said
Well, it's
you
recent most. It will cut the controversy short. That is the.
time. All
It will
right.
cut the. Just see for a minute for my satisfaction.
It's
Lords
okay.
may not.
No, no.
Kindly see for a minute.
I have indicated
My
you
lord.
in the morning
Well,
itself.
Indeed,
that
I agree to that.
either-
my lord, and
either
that's why
we'll
I'm not
take
taking.
up Take up the matter or not.
I won't take more than that time.
No,
Just
it's
see.
okay.
Well, just see it
Sir,
for 1
Mr.
minute.
Kalra will decide the matter finally.
Only
Let
for
me
my-
file the affidavit.
Only for my this one. Only for my satisfaction. But only for my satisfaction. Just one line from the Honorable Supreme Court's order. One
It's
line.
okay. It's okay. We'll consider everything.
My lord, then at least.
We'll
At
consider
least,
everything.
I understand. At least the petitioners may be considered for verification, my lord, because it shouldn't be. And
No, that's already supreme.
there is an apprehension.
Advocate General has already,
There is an
Advocate General
apprehension.
has already made the statement
Yes, there is an
before the
apprehension.
division bench.
Yes, there is an apprehension. The apprehension is this.
You come back.
These 3 orders, my lord, of the Honorable Supreme Court, they have categorically written in 2 lines that only the parties before this court will be considered. They have written that. Now, my lords, while considering,
Are you aggrieved by that?
I'm not aggrieved by that. I am saying the parties herein may be considered. That's all I'm saying. It shouldn't be. that-
If you are aggrieved by the decision of the order of the division bench, you approach the.
I'm not
appropriate
aggrieved, my
forum.
lords, but again, because they are
Then-
taking,
How can I pass an order over and above the division?
it is
bench?
not over and above that, my lords. They, before the division bench said that we will be considered. Now they are saying that whether we are eligible or not, we'll decide later, my lords. The question that I put to myself is, what is this happening?
No, no, no.
Before the
See,
division
see,
bench, they said we'll be
is-
considered.
Sir, reason is very simple.
I'm sorry, my lord.
The interlocutory application was against the verification stage.
Indeed, my lords.
So this court has still returnable debt, considering that matter will be taken up today. I said, don't do
Indeed.
that next one, because it's yet to start. But they filed an appeal before the division bench. The learned Advocate General has said the cases of the petitioners, whoever the parties are being considered, their documents are being, they are also, their verification process, their cases also been taken care. On that ground, a decision has been decided.
Indeed,
Right.
only on their concession, not on merit.
So now they are doing it.
Yes.
They'll be doing it.
Okay.
Now, issue would be,
Please.
the main writ petition would be whether the impugn notification making you ineligible or
Please.
debarring you for having that thing, whether it is legal or not, we'll see, or it is in consonance or contrary to the.
Very well. This is the last thing.
So here, your eligibility,
My lord.
urgent today, has not been decided. That is the subject matter here. The interim stage, I mean, and this interim stage, the verification, they have sought for it, they are doing it, you have been allowed to go. I mean, they said you will be allowed.
Very well. Then
Better
only this
decide
one
now.
additional
So
request.
nothing more.
Yes, yes. The verification for us before the next hearing may be completed. At least that much of
Oh, that
request.
we cannot.
My lord, then it will just go hang, it will just go on and on and on. My lord may give a date of their choice. Give a date of their choice, my lord. By that time, at least verification.
We don't have to say.
My lord, it
every-
cannot be a
every-
never-ending process.
everything-
My lord. I'm
everything
sorry, my
indefinite.
lord.
No, no, that's not the never.
My lord, for the others,
You
we
are
completed
always
it in 10
open,
days.
you are always, the doors are open for everybody.
My lord,
to
I
come
understand,
back
my lord.
if there's
But
a- if
it
you are
can't be a
agreed.
never-ending process, my lord. Then it
No,
is
it's
their
not a
case
question
that
of
it was
never
not
ending.
covered.
No,
And
they'll
so-
stick to what they have stated before
My lord, but there has to be some deadline to it, my lord. I am not asking for modification, I understand, my lord, but there can be some additional condition because the writ petition is pending here.
You are asking me, this court, to pass an order over and above the.
No,
the
I'm
order of
sorry,
the
my lord,
division
that is
bench.
the impression I must
It
clarify.
akin to
I must
it
clarify.
amounts to that.
No, no, I am
Which-
clarifying.
Which I never expect from you.
I understand. I must clarify, my lord, that is not the impression.
Sorry.
The only thing is,
Okay, thank you. We'll fix the debt, giving them a time to list them. No, I think everything you have been, for a time being, you are also safe.
yes, ma'am.
Your
I
case has been
I
considered.
understand.
What's the?
At least on whenever they are filing.
You will
their-
finally decide whether you are eligible or not.
Yes, whenever they are considering, my lords, these three judgments may be taken into account. I've already served them.
If you have served, it's okay. If you don't.
My lords, I
take it,
don't,
it's
because
okay.
on February
That's why I
25
said I expect the assistance from, not
We
only
understand.
assistance,
Therefore,
better assistance from you all. That's all.
because in February 25 also, they said we'll consider
Okay,
it.
thank you.
They'll
Heard,
come.
Mr. Kalra. Leonard. Counsel for the petitioner. And
H. Bravo Hamel.
you are also for petition.
For petitioner.
Mr. Kalra. And Mr. Leonard, counsel for the petitioner. Why this is, will release from part hard? Why this is part hard?
Because it was heard in part, there are two orders which my lord had said that will be considered as a partner, because my lord had understood the issue fair and square, my lord.
No, do you think that some other judges will not understand?
No, my lord.
Then,
My lord, we'll pray, my lord, if my lord.
and also have Mr.
keep it as a
Armajimdar,
partner
Learned
only.
Council for the Learned Standing Council.
Department of School Education.
Department of School Education. And who else? Sir? For NCT. Okay. So what is you also assist us, please. Look into those judgment. If you don't have, you furnish everyone, share your copy, everyone,
Yes, can you
all
keep
the,
one
all the
for
lawyers.
in the court file?
These are all three
Lords, Uttarakhand, Bihar, and West Bengal.
on the prayer of next prayer. Learn
Yes,
council,
wonderful.
learn standing council, Mr. Majumdar and Mr. Ayalam. Ayalam. NCT. Record all the. Let this matter be listed after 3 weeks. Listed. In the meantime, the respondents to file their response. 3 weeks, you file before the next day. All right,
Those may not release it from part or.
you never know, we don't know our.
My lord, we'll try our luck, my lord. We'll try our luck.
No, it's not a question of.
I know that. But virtually we can. My lord, it's a humble request that my lord may not release it from part. It's only because of.
No, why, I'm asking why this has been kept part hard.
My lord, because it was heard twice.
Let us see the last.
Yes, the last two orders, my lords. In order prior to that, my lord would see.
In fact, we wanted to dispose of the matter.
Indeed, my lord,
Yes,
indeed.
that's the reason I think.
And therefore, I was trying to trouble my lords with those three judgments. Because
We're
of
not
those
happy.
three judgment, nothing would be left, my lords.
Rather, we're not happy with the keeping the matter part hard. It stretches you all the time. It's haunt you. Yes. So should I release Majumdar? Last order is it's kept as part hard.
I would also pray that it be kept part hard because Lordship has gone through it. Lordship, on the next occasion, my lord, we'll finish it. That is an
Whether
assurance I
you
can.
file it or not, but you will have. to
We'll
file.
argue the matter on the next occasion.
Okay. This after 2 weeks as part hard.
We'll do it.
Any date may be fixed, my lord? Any date?
You.
29th or 24th?
29th.
3 weeks or two?
29th.
29th?
29th.
29th is fine.
Make it first week. Since you are keeping it part hard.
First.
Keeping it
First
part.
means.
Yes, yes,
First
whatever is
part hard,
convenient to-
Part hard.
not 29. After that, 1st of May, I think.
First means.
I'll be away for the last week. Last week of April, I will be away.
Then
First week of April, May.
first,
Make it on hearing this. On hearing.
if first is not.
Make it Thursday, huh?
First of May is a Thursday.
First of May.
First.
Ah.
That coincides with the last week of April. That is what I was saying.
I believe. First May, my lord would be taking it up. No?
Last week of April is not the first of May is on the same thing, no? It's on the same week. So the Lordship should be.
Oh, I see.
April to না থাকে একটু তো একেলগে পড়িব না না থাকলে দেরি হবো এটা তো 24 তে দিয়েছে
6 or 8.
6 to
Either
Eight
6 or 8.
will be better.
8
Eight.
all convenience.
Grateful, my lords, and once
Highly
again,
obliged.
grateful for a patient hearing. Deeply.
I oblige.
We'll try next time.
নোটা
We'll also try our best.
নোটা
my lords, to assist.
এটা বানাবে
I mean, try to dispose it off.
Yes, that compilation of those 3 judgments I have given, my lord.
It's okay.
It won't take more than a minute.
I would have a time to go through. I mean,
My only case is that I am covered with that. Grateful, my lords, deeply grateful.
Your lordship,
yes,
I apologize for the inconvenience. Actually, I
75.
Your lordship, please hear me out. So,
Yes,
I missed item number 24 while I was appearing in in court number 13.
so
Considering the urgency of this case, my lord,
item
item 24, my lord,
24. What happened?
the petitioner is a cancer patient, so he's really in a bad condition.
So what had
they-
happened? What order has been passed?
I was not here.
We'll record your name and we have already passed. Item 24.
Fix us a date, my lord.
On the prayer of Mr. MS, you ask him to delete that. Huh? What's your name?
M. Dakhar. M. Dakhar, Dakhar.
Take the name. On the prayer of so and so, and the constable, which this method is after 3 weeks.
Much obliged.
No one appears for the petitioner on call list after 4 weeks.
affidavit is in file.
Affidavit has been filed, my lord.
None appears for the petitioner on call. Mr. P.C. Suti Alamed. Additional senior government advocate.
Yes, my lord.
Means that he has already filed the affidavit on behalf of the state respondents.
Yes, my lord.
Next paragraph. Office note dated 7/1/2025 indicates that despite order of this court for taking fresh steps, no steps have been taken. List after 3 weeks in the meantime, we.
So I am appearing for 1, 2, 3, and 4.
Steps.
5, 6, 7, private respondent. my lord. 1, 2, and 4.
Yes.
Published. Wait, please, your lordship.
Yes.
In this case, I'm appearing for the private respondent except 4, your lordship. But this matter has been already decided in earlier 2 round of litigations
So.
by this honorable single judge, your lordship.
Hmm.
I may place that order, but today the petitioner is not there, so I don't want to place the matter in absence, in their absence. But the matter has already been decided. They're challenging the promotions of 2018. The single bench on the similar issues filed by the similar set of petitioners had decided the matter. your
So when
lordship.
it was decided,
Your lordship, it was decided on 21/3/2025.
25.
Yes.
It was last listed in 2021. So what is to be done? They may not be interested. They might have come to know that
Yes, your lordship.
this covers the case.
Yes, your lordship. May I just,
Goes against the petitioner.
yes, your lordship. May I just place the judgment if your lordship wishes?
You just tell us the.
What has happened, your lordship? They have challenged the promotion of the sister tutor, which happened way back in 2018.
Hmm.
Now, from that post, from that cadre, now my basic plea was that a promotion has to be challenged within a period of 6 months, at best to best within 1 year.
Okay, then you will see. Later on.
And that was negated. And this, all these petitioners, including the private respondent, had been promoted to the cadre of assistant matron also.
Hmm.
That's the basic issue. There was similar prayer, similar pleadings in the earlier two writ petitions also, your lordship.
You are appearing for all.
Except
Except-
4.
Who is for?
Your lordship, I'm
Not appearing for
appearing,
the petition.
I'm appearing except for private respondent number 10, 15, 17, and 23.
Hmm.
I have filed my wakalat power for
Mr.
Arsina.
Arsina appears for respondent number
7 to 9,
7 to 9,
11 to 14,
11 to 14,
16,
16,
18 to 22.
18 to 22. Who submits that? The similar issue has already been
Dada.
settled by, has already been decided by this court. You just tell them by the order dated
21/3/2025
21/3/2025
in
The
writ
case-
petition number 2940 of
in
2000
WPC 2940 of 2021,
and 6006 of 2021.
60,
06 of 2021.
2021. You just right, huh? Mr.
And these petitioners are also petitioner in that writ petition.
How about, huh?
And these writ petitioners were also the writ petitioner in 6006 of 2021.
Nothing remains.
Nothing remains, your lordship.
Mr. Herbert, in view of the absence of the, in view of non-representation on behalf of the petition, let this matter be listed after 3 weeks. We'll see.
Yes, your lordship. Deeply obliged, your lordship.
We'll do that. Yes, yes. Please, we'll finish. At 2 o'clock, we'll first.
72 of
BC.
it will be second.
Yes, 78.
My lord, yes.
Yes.
I have filed my affidavit in opposition here, but whether the petitioner file reply or not ever, my lord.
No appears for the petitioner on call. What is the matter?
My lord, during the substitution of first wife, he entered into second wife, and the order of dismissal
Mr.
was
Okay, the learned CGC.
Jesus.
Correspondent 124 submits that he has filed the affidavit. He has already filed it. Release the matter after 4 weeks. 4 weeks.
My lord, this is in earlier application, lordship fixed for final disposal. My lord, there is a observation from this report also.
This is why
I am, my lord, I am right now. I am not placing the I am, my lord. I am, my lord.
What is the matter?
Read petition. My lord.
What is the writ petition?
Read petition is, my lord. Regarding, my lord, the issue of the affiliation.
What is the matter?
Yes, my lord.
What is the matter,
My
sir?
lord, regarding the issue of the affiliation from the Guwahati University, so that I can apply for the formal approval from the BCI to start my LLB and BLLB course, my lord.
Milord, it will take some time. Matter may come up at 2 minutes.
Why you cannot grant?
Milord,
Why you are not granting a NOC?
Milord, it's Milord, as per office memorandum, Milord. Milord, we can't grant affiliation to a private college, Milord. So the affidavit is there, Milord.
As party, my lord.
So
You are a private college.
I am private.
Private
but as
college,
party,
you are running-
and this office memorandum of 2019.
The college is on.
My lord.
You have admitted this, you are still, college is running
College is not running because I am not getting the approval from the BCI, my lord.
after puja.
My lord.
After puja.
No, my lord.
Bihu.
No, my lord. One, my lord. Last occasion also, my lord.
After
My
Bihu.
lord, place a one order, my lord. That is from the Supreme Court. Because the college is because of these things, my lord, we are suffering. We are not able to give the admission to the student. So, my lord, this urgency is there. A lot of
Friday.
times, my lord, you just fix for hearing, but nothing is done, my lord.
Huh? Why this has been listed for orders?
My lord, because it is fixed in the orders, my lord. Because not for fixed on a hearing, my lord, there is an order that we dispose in the orders. This one, this is
Where is this order?
last occasion, Lordship also passed the order, my lord. Because my lord, as party, not a very big case, my lord, as party UGC, my lord, affiliation guidelines, and as party BCI rule. No NOC is required from the government in case of the private college, my lord.
F2.
F2, my lord.
F2.
Massive, yes.
There is a extraordinary request by my friend, Worship. Yeah, I want to hear my results.